My lord, may I have my lord kindly leave to mention item number 73 of your lordship's days list.
Yes.
My lord, your lordships kindly remember that on the last Tuesday, my lord, when I was going to move this application, an adjournment was sought for on the ground of Rahul Kormukar that there is a
Yes,
bereavement in
yes.
his family. Now, my lord, the matter has gone down. My lord, I know. My client is suffering, my lord. If
Sir,
your lordships
please.
kindly accommodate me, my lord.
See how far I can reach today.
My lord,
If not, please mention tomorrow.
my lord.
Because yesterday I could not.
Yes.
That's
So,
why please give me some time, 1 or 2 days. Let me see. I will try.
my lord, my lord.
I'm actually sorry to remind the matter to the lordship. On 27th of the last month, I mentioned this matter with my medical prescriptions. There is no other side. It's a
What do you want?
expedition sharing. Lordship was pleased to take up the mentioning only of mine. This is the position. Even after
Please mention tomorrow. Please mention tomorrow. Yes, call the list.
number one,
Yes.
One, my lord, I am appealing for the petitioner.
Yes. Yes, Mr. Rai. Yes, yes, start. Yes.
Yes. The documents was impounded which was executed between the parties in the year 2010.
2010. Yes.
And it was sent to the register for the purpose of
Assessment.
And now I can consider the last order, whether it will be done as on the date of execution. It is a sale deed.
Order dated.
It is some delay is there, my lord. I mentioned 12th May 2022.
Mr. Rai, after more than 3 years,
It is
Mr. Rai.
still,
Where is the explanation?
yes, I have mentioned in my initial application. I have given. I tried to explain.
Yes, tried to explain, but not
It
satisfactorily.
is my lord's consideration.
Yes. Paragraph 12, blank, dot.
It is going.
Yes. At the time of drafting, you have kept it blank, and
No.
filing also it had been kept blank, not filled up. Who is the advocate on record?
Samrat.
Yes.
Samrat.
So, Mr. Rai, unexplained inordinate delay.
They contacted the learned advocate. That date is blank, but subsequently, my lord, if you lord,
Yes, so that is vital, Mr. Rai.
one of the vital.
When the learned advocate was contacted, kept blank, nothing.
Right, and finally, because he died, the learned advocate was there, my lord. He was died subsequently. But the order, your lordship, kindly consider whether it is permissible under the law or not.
And Mr. Rai, even going by that, you have obtained the certified copy April 2024 and you have filed even after more than 1 year from obtaining the certified copy. Where is that explanation of the delay?
You will logically consider that last page 6, last 3 lines. Thereafter, after consulting with the learned advocate for the order of
Page 6, last 3 lines.
it started that after what happened,
Yes.
detected that stamp duty is not impounded, but the same was assessed by the Assistant District Sub Register
That is
Noida.
the explanation. And as such, the petition,
And such the petitioner
so
instructed.
instructed is on April 2024. But it was filed, Mr. Rai, on August 2025. Where is this explanation of more than
After
1
that,
year?
it was contacted the learned advocate with this honorable court for that purpose.
1 year.
This is a body of poor litigants from the.
Yes, Sharista, he contacted you and you waited for 1 year, Mr. Rai.
It is not my so far.
Not your Sharista.
No, this is from my register, but it is for the litigants.
Your care of,
Yes,
Mr. Rai.
yes. Now, my lord, whether, my lord, the register will assess the stamp duty or will consider it in terms of section 35 of the Stamp Act.
You have the stamp back.
Judgment of
Why did not challenge them?
Yes, it should have. It should have. But still today, my lord, I am candidate your lordship, date fixed for the deposit of this amount. There is no further progress in this matter. Then I
Give
could
me
have
the stamp back. You have the stamp back, that's it.
30. Just show you the.
It was market value of which date? When it was impounded?
No, from the date of presentation, whether it is permissible.
Has to be on the date of filing of the civil division application now, because of this delay.
That I could understand that. And not only that, well, though it was a learned court below, please to provide that the registration charge is not required, but the registrar has considered it that way.
No. Registration charge is not directed to.
That no, it was assessed in such a manner, stamp duty for payable, market value, and this is the registration charge.
Yes, but the registration charge.
The court is of the opinion that it is not required because it is not a suit under section 1353A of the.
And who are you, Mr. Rai?
I am the purchaser, plaintiff.
So you also wanted to pay the registration fee. Another petition filed by the plaintiff to deposit 3,11,000. That is the registration fee. That is by.
That is registration fee.
You wanted to deposit
the stamp duty by filing non-judicial stamp paper rupees 12,45,000.
No. Paragraph. You wanted to pay registration cost, Mr. Rai.
So 12,45,000.
No, but you also wanted to pay. You volunteered to pay the registration fees also. Nothing, Mr. Rai.
No, so what the market value from the date of execution?
So that is adjusted because you are willing to pay the registration cost. That is not the differential amount.
No.
The differential amount will not be much.
No, it will 12,45,000 is the stamp duty.
Yes, and what would be the, as per the market value on that date?
15 years back.
Yes, what would be the stamp duty?
If you currently consider the inflation index, it will be 5% per year.
And cost that will be compensated by the cost in
I could
filing of the civil action.
That my lord can impose. That my lord can impose. I cannot. And the judgment which is 2023 judgment from the date of execution, not from the date of presentation. That I.
Where is that?
Yeah.
The issue that arises for consideration. The issue that arises for
Yes,
consideration
yes,
is.
yes.
Yes.
Not answer the petition.
Yes. Don't look at the back. Yes.
No, Milord, there is a caveat. Milord, my learned friend has served. Mr. Ramakrishna Mondal. Oh,
Ghosh is appearing.
That's what I'm looking at, Milord. Why?
Your Lordship can allow this application, Lord, because
Allow
the
this application.
correction of 33, premises number 33 has been written wrongly
No,
in
Milord,
the map, and it should be 35. That is
Milord, I have certain others. My learned senior friend is correct. Milord, what happened? Milord, here the acceptance of a commissioner's report in a suit essentially for encroachment and removal of encroachment. That report has been filed at the juncture when my acceptance of written statement is on the board. The court, my defense strike out since I could not able to file my written statement within the statutory period. My application is there for acceptance of my written statement. Within that juncture, the report submitted. The court considered, since the plaintiff have filed a objection to the report stating only a holding number is wrongly written. that was kept pending. But the court considers, since I have not yet filed my objection to the commissioner's report, ultimately commissioner's report has been accepted.
That
By
has
the
to be
same,
accepted.
but I'm
sir.
coming, Lord, I'm coming. By the same impugned order, Lord, my acceptance of written statement has also been accepted. So
Yes.
my application for acceptance of written statement allowed.
He is not challenging that.
He is not challenging. So, Lord, as per Lord, your Lordship knows, Lord, modular India, my right to file, Lord, the ought to object in any interlocutory application comes when my defense came back. By that impugned order, immediately thereafter, I taken out an application that, look, allow me to file an objection to the commissioner's report. There are certain objections, Lord, on my behest. Since my written statement at that juncture was not yet accepted, so kindly allow me ex parte that the application for acceptance of commissioner's report, which has been done, recall that order and allow me to file an objection.
Sir, Mukherjee, acceptance is automatic. Once a commissioner under order appointed under order 26 rule 9 files a report, it automatically forms part of the record and
But
forms evidence in the suit. So acceptance is neither here nor there. Only you may have a right to cross-examine the commissioner.
Yes, that's
So that
on
what,
the basis of not the objection, which may be allowed to.
what do you say?
He is a transferee. Original written
But
statement has been filed.
Maybe,
By the the original
Mr.
defendant.
Ghosh, maybe, but he has a right to cross-examine. That's the limited right.
So that is there.
So that is there, but that has been, he
It has
says
not
that
been
that has been
refused.
turned down.
It has not been done.
That is, Mr. I have not looked
No,
at
Madam,
the appeal order.
kindly takes up now. Lord, the recalling application is at 148, but Lord, kindly takes up first, Lord, the order impugned before you, both the order. 14th March 2023, has your Lordship got it?
Yes.
Kindly takes up, Lord, the operating portion. Lord, here, the acceptance is the first part. Has your Lordship got it?
Yes.
Lord? The second part is, Milord, my application for acceptance of written statement, belated written statement, accepted upon payment of cost.
That he is not challenging.
That he has not challenged. Acceptance of commissioner's report I have challenged. Recalling application is being dealt with by order number 97. 6th of August. Last page, Milord, of the
page.
Yes, next page, Milord. 6th of August 2025.
6th of yes. Consider a petition wherein mistake on the part of the is pertinent to mention that a appraisal ought to have brought the fact. What is the mistake?
But since I have not brought to the notice.
No. This is a mistake means I think some
Lord,
plot number or something. Defendant is asking this court to consider a petition wherein
This is,
mistake
Milord,
on
the
the part
plaintiff.
of the commissioner.
This is the plaintiff. Plaintiff filed an objection to the commissioner's report.
No. Defendant is asking this.
No, Milord, this is, Milord, wrongly written.
Wrongly
It ought to have been plaintiff.
Alright. And it is pertinent to mention that on perusal of the ought to have brought the no written objection. No, it's defendant.
It is defendant's
Ought to
case.
have brought the fact regarding the
Yes.
petition since no written objection has been filed in spite of
This
the
petition is of
Where is
the
that? Where is
plaintiff's
that?
petition. Milord, yes. Page 138 kindly takes up.
4th of April 2023. Where is that?
Yes, 138.
Yes.
Page 138 kindly takes up. This is
a plaintiff.
This is plaintiffs. That's why I have not filed any objection to the commissioner's report. That stage has not come.
Oh, to put the correct premises.
Yes. So that's why my learned senior friend says, kindly allow the revisional application. His prayer, so far as regards the correction of only the holding number, that may be incorporated. I am not on that. I have not yet given an opportunity to file an objection to the commissioner's report because my application.
Defendant to place for adjournment in respect of the hearing of the application seeking recall.
Yes.
Where is that?
Recall is, Milord, previous order. I prayed for recalling of the order by virtue of which commissioner's report has been accepted. Order dated 14th of March 2023, first part of that. Because it has two parts. By the same breath, the learned judge has accepted the investigation report and.
No, this was fixed on, this application for recall
Yes.
was fixed on 19th of April. What happened to that? What happened on 19th of April?
19th of April is cross of PW1.
No. Please look at the order dated 14th of March 2023. Last paragraph.
Yes.
Last paragraph. Penultimate paragraph.
This is, Milord, this is recalling of order 14 rule 2 application.
No. 4/11/2022. Oh. So where is your application for recalling of this?
This order, yes, Milord, kindly takes up, Milord, page 148.
148.
Yes. Prayer portion is at page 149.
149, yes.
Kindly
Please to recall the order dated is
14th.
acceptance.
Acceptance.
Acceptance cannot be recalled.
That
So
your
if you-
lordship clarify, my lord, I have an opportunity to file objection and cross-examine the commissioners, my lord, to that limited extent.
Have you made that prayer, Mr. Rai?
My lord, yes,
Mukherjee?
my lord,
is
I
that?
takes up page 148 and 149. My application
show
is
me.
essentially for that.
Where is that you want to file a written objection and to cross-examine?
My lord,
Show me
kindly
from
takes
your
up paragraph 5. For such reasons, the said order dated such and such is required to be recalled in the part of relates to the
Only
acceptance of
recalling.
commission. My lord, I am coming.
Opportunity to file a
And
written
the,
objection.
yes,
But in the prayer, you have not said that.
no, my lord, I have not said in so many not language, but paragraph 5. I
Well,
said.
Mr. Ghosh, what do you say to this? He has a right to cross-examine the commissioner.
Look, can you see the age of the suit?
Maybe
Pending
cross-examination
delay.
acceptance cannot be recalled because it automatically forms part of the suit. He has a right to any party has a right to cross-examine. That's provided under Order 26 Rule 10(2).
That is there, but
Yes.
he has not prayed for that before the
Now what happened at the
But
relevant
here
point of time,
he
his
is
written
improving.
statement was not there. Now it has been accepted. So he has the right to contest, not a limited right to contest.
Now it has extended.
Yes.
Yes.
Now you have also not challenged that order, acceptance of the written statement. So he has a right to cross-examine the commissioner. Let him file because cross-examination has to be limited to the objection. Acceptance is not dependent on the objection, but cross-examination has to be limited to he has to make out those points. Cross-examination limited to that. এই দেখি বইটা দিন, CPC টা দিন। আসুন, this CPC. Yes, Mr. Ghosh, anything more?
No, my lord, this is and your lordship kindly, my lord, direct the expeditious disposal of the matter.
Yes. Mr. Mukherjee, how soon you will file a written objection? No prayer for adjournment. What is
7
the next
days.
date?
7 days.
What is the next date fixed in the suit?
19th September. 19th September.
19th
Very well,
September.
my lord. By that time.
File it 1 or
Yes.
2 days prior to that, so that
Passing an advance copy to my lord's
19th.
একদিন আগে বা দুদিন আগে ফাইল করে
This application under Article 227 of the Mr. Ghosh, I am allowing your
Three, my lord, I beg to appear on behalf of the petitioner, defendant petitioner, before your lordship. In a suit for easementary right, my lord, of a passage to go to the, my lord, the schedule.
What is the impugned order?
By the order impugned, my lord, my application for recalling is being turned down. What happened?
Recalling of what?
Recalling of an order of mandatory injunction along with an order of police self for implementation of that mandatory injunction, which is not there in the plaint. That prayer is not incorporated in the plaint.
Which order you are challenging, Mr.
Lord, here, Lord, your lordship kindly takes up order dated 28th of July 2025 is under challenge.
28th of July is petition for vacating the order of ex parte hearing. That was rejected.
Lord, I am coming, Lord. No, not only that. Thus, this court kindly consider.
We are not agreed by that portion.
No. I am coming, Lord. Thus, this court is of the opinion that the petitions dated, all the petitions, Lord, filed by me is of 7th of February 2025. I shall show before your lordship what happened. Entire order sheet. Lord, kindly see the entire order sheet. I am coming. Kindly takes up now the plaint. Page 14 of my lord's brief. Kindly keeps it not aside, Lord, entire order sheet. I will show before your lordship. What is the gamut of the suit? Lord, kindly takes up page 18 of the plaint.
Yes.
বাদীপক্ষের ক এবং খ তপশিল বর্ণিত বাস্তু বাড়িতে স্বাভাবিক.
What happened? One, the application for vacating the ex parte hearing was rejected.
All the application of
What are the other application?
Yes,
That is one application. What is
one
the other
application is for vacating of ex parte
that has been rejected.
showing cause. Another is 711. Another is, my lord, acceptance of written statement and recalling of both the order by virtue of which mandatory injunction is being granted.
Acceptance of written statement if the vacating goes.
Yes, one statement, all are interlinked, my lord. But mainly, my lord, we are concerned, my lord, with regard to two orders. One is mandatory injunction, beholds the plaint of the, my lord, suit the court has granted, and another is for implementation of.
You have filed an application for recalling of that.
Yes. Specific, not making a specific.
Mandatory injunction,
But how-
recalling rejected, revision, how it is
No,
maintained.
I am not recalling. I am only on recalling. It's an ex parte.
Recalling
It's an ex parte.
rejected, Mr. Mukherjee, recalling rejected is an appellable. If the recalling of a mandatory injunction
My lord,
rejected,
it's if it is ex parte. If it is I am not on merit. my lord.
maybe ex parte
I'm
or
not
not
on
ex
merit.
parte, you have to now challenge if the recalling is rejected, it's the parent order which is to be challenged. It's an appellable order.
But I'm coming only one thing. Lord, kindly consider, Lord, one aspect of the matter. And see, Lord, what is the plaint and how it has been dealt with by the learned judge.
All right, there is no scope to pass any interim order
Lord,
now.
I am only praying for all further proceeding. Lord, the
Of
court
what?
of the suit.
Ashun.
Nothing.
It prima facie appears to this court that
I am for the petitioner.
yes,
This is for expeditious disposal of a misappeal pending before the Debt Recovery Appellate Tribunal. But fact is,
penalty, you are moving expeditious hearing matter.
fact,
Yes.
fact is this, my lord. I obtained an order, my lord, under section 14 from the Chief Judicial Magistrate, Kolkata, for delivery of
You are
possession.
the bank,
I'm the financial
financial institution, yes.
Now, that was challenged by, my lord, some persons claiming to be in occupation of the property, my lord. And
Before the
only
DRT,
DRT, only ground was that some.
what happened with the DRT rejected?
Everything stayed. Everything stayed, my lord, on the ground that some lawyers' chambers are involved. I preferred an appeal
Yes,
against that order of, my lord, staying all proceedings. That appeal is, my lord, continuously being adjourned, my lord, saying you settle.
4th of November it has been fixed.
Fixed, my lord, but every date, my lord, the tribunal is adjourning. Kindly see the last order, my lord. We don't want to settle.
You don't want to settle. Why, Mr. Bennett?
Let the point be decided, my lord.
Let the point be
This
decided.
application under Article 227 of the Constitution.
Lord,
Yes.
I appear on behalf of the petition.
Yes, yes.
My lord, by the impugned order, my lord,
It has not been served.
lord, there was
Yes.
no caveat, my lord.
Yes.
My lord, by the impugned order, my lord, my application for amendment has been rejected, my lord.
Amendment of?
Amendment of plaint, my lord.
Yes.
My lord, it is not a case, my lord, where I am making out a third case, my lord. I have already stated in my plaint, my lord, kindly, my lord, comes to page 9 of the divisional application.
Yes.
Para 10 on page 10, my lord.
Yes.
Para 3. My lord, the defendants are the strangers in respect of the suit property.
Yes.
This is my specific case, my lord. Thereafter, my lord, page 12, para 11 and 12, my lord. That the defendants are the strangers in respect of the suit property and they have greedy eyes over the suit property, being real estate agents. That the defendants for their illegal gains without having any right, title, interest and possession in respect of the suit property, trying to take forcible possession of the suit property by illegal means.
Mr. Mondal, do you have an extra copy
Extra copy
of the civil division application?
Yes, my lord.
You have given?
Yes.
Yes, yes. Proceed.
My lord, then my lord, kindly my lord comes to page.
Yes, show me your amendment application.
Yes, my lord. Page 30. Page 30 is the application. My lord, schedule is at page 32. After para 20, my lord, 20A, the plaintiff is also entitled to get a decree for declaration that the defendants are strangers to the suit property. And 20B, my lord, the plaintiff is also entitled to get a
At
decree
what
for.
stage you have filed this application?
Lord, that is at the stage of argument.
This
No,
application
my lord,
under
my lord,
Article
only one thing, my
227
lord, this is not.
Constitution of
My lord,
India.
I have taking away their right, my lord.
Thank
I'm
you.
not.
Yes, next.
Number 6, my lord, I appear for the petitioner.
Please take it back. You don't want this.
6, my lord, I appear.
Yes, please check the page number.
Yes.
Number 6, my lord, I appear for the petitioner, my lord.
I appear for the caveator.
Yes, yes,
The caveat has been served.
yes,
My lord, this is a suit for declaration and permanent injunction,
yes,
restraining the defendants from encroaching upon or disturbing my construction work.
yes.
Now, my lord, I file an application under Order 39, Rule 1 and 2. My lord, court grants interim relief. My lord, unfortunately, my clients do not lodge a caveat. My lord, they went up in appeal. In misappeal, the court, my lord, stays the order. Challenging that, I am before your lordship. Now, my lord, kindly have a look at both the orders, my lord, as well as the scope of the plaint. My lord, your lordship will find the plaint from page.
For one ILR Calcutta page.
I am also saying this. Kindly seize the plaint as well as the injunction. Final relief granted at ad interim stage.
What final relief granted?
Kindly seize the plaint once.
What final relief granted?
Kindly seize, my lord. Just at the
Yes, what is the final relief granted?
plaint, my lord. B. Where B.
Where B?
A
My lord, he is
permanent injunction restraining defendant and the main and agents from obstructing plaintiff from raising construction over the suit property, and also restraining the defendant and main and agent from disturbing the peaceful possession of the enjoyment of plaintiff in respect of the property.
Where is your stay application, Mr. Bhattacharyya? Please give your stay application which you have filed before the learned judge of the appellate court. You have incorporated other documents.
Yes.
Can you incorporate other documents in an appeal?
No.
Arising out of Order 43 rule.
I have incorporated their documents only. Not a single my document is there.
Then, how come the learned judge of the appellate court arrive at this finding? Please kindly come to the second page of the impugned order, middle paragraph. The Oxytown Cooperative Housing Society Limited has not been made a party to the suit pending before the learned trial judge. What is the basis of finding of this court?
Kindly seize, my lord. The
On what basis, on what document this learned judge of the appellate court arrived at this finding?
may I just give me 1 minute?
It's must be on the basis of your document.
It's
Cannot
their
be on-
document. They
no,
have-
no. Where is my document, my lord?
They have claimed seven cutters of land. They have purchased 7 cutters of land. They are making construction over 9 cutters of land.
Yes.
They have purchased 7 cutters of land.
That is neither here nor there. Where is the case made out in the stay application with regard to Oxytown?
It's a cooperative land. Cooperative members have been.
But how can it be a cooperative land, my lord? He's admitting that.
Mr. Bhattacharya, how can these facts be gone into in an appeal arising from an ad interim order of injunction?
Final relief granted at ad interim stage.
Mr. Bhattacharya, maybe that I will consider, but due documents cannot be allowed.
I have not given a single document. It's entered.
Show me from his plaint. Show me from his plaint that only those documents were
Kindly seize, my lord.
the basis of this Oxytown Cooperative Society.
My lord, need not go there. But kindly seize.
No.
But kindly seize their plate, my lord.
Whether I will go, it's the appellate court has gone there.
But
How could the appellate court
when
go
it
there?
comes to the page 17 of the plaint, my lord.
Page 17?
Of the revision application,
Yes.
17. There are 3 schedules, my lord.
Yes.
All piece and parcel measuring, kindly see schedule 1.
Yes.
All piece and parcel measuring 4 kathas of 7, 4 kathas out of 7 kathas, 7 chitaks, so and so square feet.
Yes.
First schedule, I have no difficulty. 2, all piece and parcel of land, 3 kathas of 7 chitaks. I have no difficulty. These 2 portions have been purchased by them. Now
Yes.
comes to 3. All
Yes.
piece and parcel, 1 katha of 15 chitaks.
Yes.
Well, how this is not their property. They have not purchased. But they have. But kindly see the deed.
Can it be?
Kindly seize the deed once. They have
Which
issued this deed which they have reside in the trial court.
Show me. Where they have relied, which deed?
If my lord, it is not paginated,
Yes.
just
Yes. Are you making construction, Mr.
Yes.
Mukherjee?
he is making.
Yes, my lord, we are making construction in our own area, and that has been done for a long time. Today, my lord, what is the gamut of the dispute? I'll tell your lordship. There's nothing to do with Oxytown.
Yes.
There are some cooperative members who are, my lord, hindering my construction.
This
Your
is the,
Lordship will find a chain of events. My Lord,
what is
I have also made application under section 144.
Deed was filed by them.
them in the trial court.
Now, my Lord, kindly also looks into the observation made by the appeal court, my Lord, which is absolutely beyond the pleadings.
It's they're
So
saying
this
that
is they have purchased one katas also.
how?
Yes,
Not-
but that question of how will be determined in trial.
Mr. Bhattacharya, how can that be decided now at this stage?
But they are constructing over the cooperative property. They're changing the nature and character there.
Yes.
That is only a mere allegation. There is no suit on their part.
But
Have
kindly
you filed
see,
your written
but
objection?
kindly see this.
Have you filed your written objection?
No,
How soon can you file your written objection?
3 weeks, but main
Why 3 weeks? What is the next date fixed in the trial court?
trial court. I don't know. I take his.
Yes, Mr. Mukherjee, what is?
My Lord, even I am not aware, my Lord.
Let them abstain from making any
Yes,
construction.
please don't make a construction for the sometime. I'm directing the Lana trial judge
Yes.
to decide the injunction.
No construction to be made.
Ashwin, this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order dated July 31, 2025, passed by the Lanet District Judge 24 Parganas South at Alipur in miscellaneous appeal number 245 of 2025. Full stop.
Only one indulgence, my Lord, since we have also not filed a written objection to the appeal, my Lord, 2 weeks' time may be granted to us, and thereafter your Lordship will expedite the appeal.
I am directing. What is the necessity of going through the appeal? Let the trial court decide the injunction application, because this is against an ad interim injunction.
Yes, my Lord. Yes, my Lord.
Unnecessarily, it will be delaying.
That would be the best, my Lord. That would be the best. But they will keep on extending the appeal court's order, my Lord. That is the only difficulty.
That is making.
I agree. But in the meantime, they did not make any construction.
No, that we will not.
This application ki bolna? First up, the plaintiff petitioner, the petitioner herein filed a suit for filed a suit for declaration of title and for permanent injunction restraining the defendants' opposite parties and their maiden agents from obstructing the plaintiff opposite parties, from obstructing the plaintiff petitioner from raising construction over the suit property and from disturbing the peaceful possession of the petitioner in respect of the suit property. First of the learned trial judge passed an ad interim order of injunction the learned trial judge by an order dated June 25, 2025 passed an ad interim order of injunction restraining the defendants' opposite parties from disturbing the possession of the plaintiff petitioner or obstructing the plaintiff petitioner from making any construction over the suit schedule property till for a limited period. First of challenging such order, the defendants' opposite parties herein preferred a miscellaneous appeal, and the learned judge of the appellate court, by the impugned order, passed an order of stay of operation of the ad interim order of injunction passed by the learned trial judge for a limited period. First up, the learned advocate appearing for the petitioner submits that the learned judge of the appellate court, without giving any opportunity to the petitioner to contest the stay application, passed an ad interim order of stay. Mr. Paragraph, Mr. Bhattacharya, Mr. Mukherjee, learned advocate. Mr. Bhattacharya, learned advocate appearing for the opposite parties submits that the petitioner do not have any title in respect of a portion of the suit property measuring about 1 kathas,
15 chitaks, 35 square feet.
measuring about 1 kathas, 15 chetaks.
35 square foot with 100 square
Uh,
foot RTS.
35 square feet. Full stop. He further submits that the petitioner is trying to change the nature and character of the suit property, and if the petitioner is allowed to make construction, the defendants opposite parties herein will suffer irreparable loss and injury. Full stop. After hearing the learned advocates for the respective parties and considering the materials on record, this court finds that the suit property is measuring about 9 katas, 6 chetaks, 35 square feet, and
No, my lord, the suit property is 7 chitaks. They are saying that it is 9 katas. We are saying that it is.
But kindly see, if he says so, then 4 kathas and 3
how
kathas
can
is
it
7.
be if you add this total
Yes, yes. It will be 9 katas.
Kindly record his
Nine.
submission that he is owner of 7 kathas.
Though the suit property is measuring about 9 katas, 6 chetaks, 35 square feet, but there is a dispute with regard to the title of the plaintiff petitioner in respect of 1 katas, 15 chetaks, 35 square feet. Full stop. The property is not a demarcated one. Full stop. It is well settled that an order of injunction cannot be stayed at the stage of admission, as the same would amount to allowing the miscellaneous appeal at the stage of admission. First of all, for such reason, this court is inclined to interfere with the order passed by the learned judge of the appellate court. Full stop. However, this court also cannot shut its eyes to the fact that if the petitioner is allowed to make construction in the meantime, the situation would become irreversible. And for such reason, this court is inclined to pass an order restraining both parties from restraining the
I am not constructing.
restraining the petitioner from changing the nature and character of the property till the injunction application is disposed of by the learned trial judge. Full stop. Since the miscellaneous appeal arises out of an ad interim order of injunction, no useful purpose would be served by keeping the miscellaneous appeal pending. First, with the consent of the learned advocates for the respective parties, the miscellaneous appeal number 245 of 2025, pending before the learned district judge 24 Pogana South at Alipur, stands disposed of. First up, the yes, how soon can you file?
2 weeks.
The opposite parties herein shall file the written objection to the injunction application within a period of 2 weeks from date. Full stop. Reply thereto, if any, we file
1 week, 1 week. 1 week after the vacation month.
Thereafter. Full stop. The learned civil judge, junior division, which court?
But this is at Alipur.
Second additional court.
Second additional court, Alipur.
Second additional court at Alipur is requested to make an endeavor to dispose of the injunction application as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Full stop. Pending disposal of the injunction application, the plaintiffs are restrained from changing the nature and character of the suit property.
Deeply observed.
Yes. Yes, call the next matter.
Well, a defendant in a suit for declaration and permanent injunction Well, 2018.
What do you want? What do you want?
2018, three petitions were filed. One was an order 26 rule 9, one at order 1 rule 10 and order 6 rule 17. Well, the
Order
learned
6, Rule 17, Order 1, Rule 10 and
pending. Order 26 rule 9. 8
Order
years, my
26,
lord,
Rule
after
9.
yes. After 8 years, the commissioner has finally submitted his report.
Order 26, Rule 9, by which order it has been fixed?
My lord, that was by the order dated 13th of
What is
October
the next date fixed?
for 18 December 2025.
This application under Article 227 of the yes. Yes, Mr. Banerjee.
Lord, a very short question. Short question is, my lord, that 7.2 and 7.2 and 7.1 application disputing the relationship between landlord and tenant was filed beyond 13 days. Now, my lord,
30 days.
beyond 13 days. Now, my lord, 13 days or 1 day or 2 days, my lord, as per judgment of the Supreme Court, my lord, till today, Lord, application under section 5 is not maintainable. Lord, on that ground, 7.1, 7.2, though raised a dispute as to the relationship between landlord and tenant was rejected.
Was rejected.
Yes.
Yes.
No, my lord, that is right. My lord, against that order we came up before the High Court. High Court is pending because there was a matter.
Mr.
pending
Banerjee,
before
if
the-
you say that
No. With regard to that, I have no case.
remains with the
My lord, with regard to that, I have no case. What I'm submitting before your lordship, with regard to that part, I have no case. Now, my lord, with regard to the second part, that 7.3, without deciding the relationship between landlord and tenant, I am 45 by the judgment of this honorable court. One is division bench judgment, another is Justice Morari Mondatto. That issue is to be framed, and issue and relationship must be decided, then 7.3 can be. Lord, that point, my lord,
Mr. Banerjee, there is something different. Those are under 56 Act. Now under 97 Act.
97 Act relationship.
It's automatic, maybe, but it's automatic. Once 7172 gone, then 73 it's
Automatic. But my lord,
not
question is,
necessary.
now, those are the exception. In a case of relationship between landlord and tenant, because in a case of relationship between landlord and tenant, to comply the payment of admitted rent under section 7.1. Consequently, 7 apply. Until determination is made. On that ground, there was
7-2 gone not within time. So you cannot now turn back to 7-2.
no, two. First is if 7.2 goes, Then, my lord, my case is in objection that I have paid entire money fault 2017 by other co-sharer landlord, and he was the party to the suit. Other co-sharer landlord. I have a judgment on that. Lord, can I praise that judgment before your lordship? If one landlord, five landlords signed the document creating tenancy. Otherwise, law is only the co-sharer can be a landlord and he can file a suit. Only exception is that if all the, because under the 1997 Act, we are necessary to prove the property. Now, under 1997 Act, only the exception suit. Now, that annexure was also made in 17th objection, saying that the other co-sharer, co-landlord is one of the landlord of the dependent. And Lord, he signed the document. He signed all the he accepted with effect January 2016. Now, Lord, his case is that I am a default since January. Now, Lord, January 2016. Terms of 7.1 or 7.2, redundant in the eye of law. But exactly that is my point. Lord, your lordship kindly look to the judgment of Lord Murari Mohan Datta. Lord, here is a case 17.3 objection was raised relationship between landlord and tenant, and court held that it has to be decided. And relying upon division bench.
There are many judgments, Mr. Banerjee, on this. Even if 17.1, 17.2,
No, automatic.
17.3,
Automatic.
17.3,
I am not automatic, but in a case where dispute relationship between landlord and tenant, Lord, I am not required to comply 7.1 or 7.2. A state I shall fight out the case. Because I have a document to show that the other landlord accepted rent of others. I have annexed those documents.
So according to you, there is no rent due and payable.
Yes. It is required to be decided. But the state on the basis of rejection of the defense. And Lord, special bench judgment, your lordship kindly see the Honorable Justice P.N. Mukherjee and N.K. Sen. Kindly look to this. Lord, Lord, 11 page 152 right hand column, in our opinion, 152 right hand column, in our opinion, then as held in the aforesaid case cited any kind of dispute which affects the amount of rent
right column, which portion, Mr.
Lord, towards the bottom.
What's in our opinion? Yes.
In our opinion, then as held in the aforesaid case cited any kind of dispute which affects the amount of rent payable by the tenant, including a dispute as to the existence of relationship of landlord and tenant between the parties, will be a dispute under or within the contemplation of subsection 2 of section 17. A dispute as to the existence of relationship of landlord and tenant between the parties does, in our opinion, as already sufficiently indicated above, affect the question of rent payable by a tenant to a particular landlord. And in that view of the matter, in a case where such a dispute has been raised, unless and until the court has decided and determined that dispute and made an appropriate order under subsection 2 in question, striking out the defense under 17.3 can arise, provided of course, as held in the latter, but earlier reported case, so and so was also much earlier, but latter reported case, Gujarat Printing Press, 64, that the dispute is a bona fide dispute or otherwise this said subsection 2 would not be attracted. Then my lord, your lordship kindly come to, we accordingly make this rule absolute, set aside the order of the learned Munshi and send the case back to him for reconsideration of the issue number 2 and the plaintiff's application under section 17(3). But my case is, Lord, your lordship, and then your lordship kindly look to the division bench judgment of the Honorable Court. If one landlord object, my lord, then in that case he cannot file a suit against me.
Yes, that is
That is another issue. That issue can be raised, my lord, at the time of final hearing.
yes, one co-owner can file if the other co-owners do not
Right.
object.
And my lord, then your lordship sees that in my application objection, we have said that in our objection, application under 7, Lord, 83, your
What
lord,
happened to the other civil division applications?
other civil divisional application is pending. I will withdraw that. Practically, after the judgment in 2025, Lord, section 5 is not maintainable. Lord, I have brought that judgment, but that is the no law now. Now, my lord, the law is no longer res integra, my lord, in 19.
That is CO 389 and CO 2674. You will withdraw these two applications.
Yes, yes. Practically nothing remains. So far, another matter, my lord, I will not withdraw because there he said, court said,
Which matter you will not withdraw? Please specify which you will withdraw, which you will
কোন
not
ম্যাটারটা
withdraw.
সেকেন্ডটা যেটা ই করবে রিলিজ করে দিল ওটা অ্যাসাইন হয়নি বলে
Lord, which was assigned, my lord, may I place before your lord?
Assigned before?
জাস্টিস
Before Honorable Justice Sompal Sarkar.
I think this should be also assigned to them.
Lord, that is with regard to, no, that was not assigned, my lord.
দিস 2674 এইটা ও রিলিজ করে দিয়েছে
389, CO 389 of 2020.
দ্যাট ইজ ফাইন
That I will withdraw because section
389 of 2020.
20. That I will withdraw.
2020 or 2023?
2080 of 2020.
That
And
you will withdraw.
that I will withdraw. 389
This
of
is against what order?
against the order of rejection of an application under section 5, consequently 72.
And what is the scope of CO 2674 of 2023?
2674 was that the court observed that say when 72 is rejected, automatically 73 will.
So, but what is this order then?
This order, my lord, 73 was filed, 73 was allowed. Impugned order is 73 filed and 73 was
দ্যাট আই
allowed.
হ্যাভ অ্যানেক্স
Please show me the, do you have a copy of that 2674 of 2023 copy of the civil division application?
T89 din na
No, no, not 389.
Yes, my lord.
2674, wherein you have said
Lord,
that,
this is 389.
no, 389 you want to withdraw.
Another I will give you, lordship.
Yes.
Lordship, kindly look to this. And 2624.
7
So 2674.
2674 of 2020. This is plot released by Lordship Honorable Justice Sompal Sarkar. On the ground, it was not assigned. Second matter was not assigned. This is against the order.
So 389 you will withdraw.
Yes, my lord.
Yes, what
Practically
is
nothing.
2674?
And this is, my lord, with regard to that order, Lord, in which the court held that automatically it will be. But ultimately, final order has been passed when section 7, subsection 3 was filed.
But what is this order? I cannot. Coming to the section 72 application, 72 application was rejected on the ground of section 5 in
Right,
389.
right.
Now what is this 2674? It says again 72 automatically stands rejected.
No, my
How?
lord. How? That is the reason we came. Thereafter 7-3 application was filed. Naturally, the earlier order was filed, that is why this order has been passed.
But it has also lost its force because if you say 7-2
Not
is
in
beyond time, 7-2 is beyond time, by this 7-2 was rejected. Please look at the impugned order.
Yes,
If
yes,
7-2 is rejected, there is also nothing in this matter.
Yes. nothing in this matter, that is pending.
No, this is also 2674. So why are you proceeding with this then?
No, because separate order has been passed under
Please see this 2674. That is also 7-2 rejected.
7-2 application, it is submitted by the last of the learned advocate for counsel for the plaintiff that since 7-1 has been rejected by this court, the application 7-2 automatically should be rejected.
7-1 rejected, 7-2 rejected. But you say, Mr. Banerjee, you submitted the 7-2 is also beyond time. So 7-2 also cannot be decided on merits. So there is nothing wrong in that order also.
7-2 cannot be decided on merit because of bad by limitation.
Yes, but here it says 7-2 rejected on the ground 7-1 was rejected. Whatever may be the reason.
But factually, my lord, 7-1 was rejected and 7-2 was rejected on the ground
Please
of
see the operating part of this order. It also says 7-2 rejected.
7-3 was not blood ordinary.
Not 7-3, 7-2 by that order. 7-2.
Automatically should be rejected.
So 7-2, not 7-3.
Yes.
Now
So what remains in that? That civil division application also nothing remains.
No, thereafter he said that the defense of the defendant should be struck up.
Should be struck off,
Should be struck up.
but not struck off by that order.
Struck off by that.
It has been struck off by this order.
There has been a struck off by this order. That's why. Yes.
The issue that arises for Yes. আচ্ছা ওটা একটা লিখে দেবেন মিস্টার ব্যানার্জি yes দুটো please take it back that
Because one of
এই
the
দুটো ফেরত দিয়ে দিন।
judge's judgment is not required at this stage. That judgment is.
That is why I've
that is
given it to you. Yes, call the next matter.
Item number
Grateful Lordship.
Yes,
May it please your Lordship.
yes,
Sir, I am appealing for the plaintiff petitioner.
yes.
But it's a very short point involved, Lord. In a suit for declaration and permanent injunction, Lord, opposite party one filed an counterclaim.
Yes, file the counter claim.
In a suit for declaration and
Opposite parties has filed a counter
yes,
claim.
opposite party number one.
Yes,
And thereafter, Lord, I filed an application under order 866C. Well, that has been
for
rejected.
execution.
Yes, for execution. Lordship, before that, Lord, Lordship kindly comes to, straightway comes to page 41, to their counterclaim. Whether at all it
Please,
can be
please,
treated as a counterclaim or written statement, I fail to understand. Lord, right from the beginning, page 41, annexure C. Well, all along paragraph wise, they have denied this and very evasively denied. I have also stated. And
Yes, yes, yes.
and Lordship will kindly straightway come to
Which page?
page 41. 41 onwards, 41, 42, Lordship kindly says, this is a written statement.
Yes. Where is the counter claim?
Not, although it is, it's a counterclaim. The court accepted that and Lordship will kindly straightway come to the order impugned. The last paragraph. The most significant thing is that, may I place the order last portion. On perusal of all the plaint and counterclaim of the parties, I am of the opinion that this petition of the plaintiffs is it should be TOO, too premature at this stage, but there is no reason why it is too premature. And the same means the application shall be disposed of while disposing of the title suit along with the counterclaim. Very good, Lord. It was
Your application.
I'm coming to it. Then the next line, the petition under order rule 6C of the CPC is hereby considered and rejected at this stage. In one hand, the court says that it will decide it at the time of hearing of the plaint and counterclaim. On the other hand, the court says that it is rejected. Absolutely a non-application of mine. Absolutely. Lordship, can you see the last two sentences? It is too premature. Why premature? No explanation, nothing.
The issue that arises for consideration
Release. Release, my lord. Once Mr. Bhattacharya appeared.
Which matter?
No.
This matter?
No, not this, my lord. If your lordship permit me, my lord, but there is some urgency because, my lord, if your
Which matter?
one matter, my lord, I have already filed, my lord. My lady is at.
Mukherjee, unless that appears in the list, how can it be
My
released?
the only problem is that, my there is some urgency, my lord. I have the, my lord, the,
When have you filed?
I have to file, my lord.
File it, give the number, it will be listed.
I mean, DA number DH. File for the number.
For that, how can it be released, Mr.?
No, not that. I'm not paying that. File for number.
Yes.
My lord, the instant revision is filed challenging the application, challenging the allowance of the Section 5 application filed by the opposite party wife. My lord, there is a matrimonial suit.
Section 5 in connection with what proceedings?
Order 9, Rule 13, my lord.
Order 9, Rule 13. So
Order
you
9,
have
Rule
obtained
13.
an ex parte degree.
Lordship.
File an application, wife file an application under Order 9, Rule
Order
13.
9, Rule
Section 5.
13.
That was allowed.
That was allowed. Section 5 was allowed.
Yes. Why you don't? Why you want
My
to
lord,
walk over? Please contest the suit.
My lord,
Have a contested degree.
my lord, there is a there are various suppression of the fact, my lord, on the part of the wife, my lord. That is why I have come.
Otherwise, what is the suppression of fact?
My lord, suppression is that regarding knowledge of the expertise decree. My lord, the earlier service, in the judgment, it is reflected that the service was done. And page 16, my lord, if you kindly take a trouble, my lord, page 16, my lord.
Yes.
Page 16, second paragraph, my lord. Internal page 2.
Page 16, second paragraph.
In this case, notice was served upon the respondent wife, but respondent did not appear before this court, and hence the case is proceeded ex parte against the respondent.
Yes.
Thereafter, the order was passed on 13th January 2025, and the decree was drawn up on 31st January 2025. Subsequent
13th January, decree was passed. And when the application was filed?
Application was filed on 1st July 2025. And
1st of July 2025.
2025, my lord. And there is no explanation of delay of there is no explanation of delay.
Where is the application? Section 5?
Section 5 application, my lord, page 30, my lord.
30?
Yes, my lord, page 30, 30. 30 and 31.
Yes.
There is no whisper of explanation of delay. Only 150 days delay. Now 150 days delay is date of decree. If we count 150 days from 1st July, it will come to 31st January 2025.
No, I
paragraph 9, my lord. Paragraph 9, page 31.
Paragraph
the total
9.
delay for filing this JME's case number is 150 days from the date of decree. So date of decree, so that means she has knowledge from that date of decree. Date of decree she has knowledge. Moreover, in the before the protection officer, my lord, page 33, my lord, ADM additional district magistrate, district Paschim Medinipur, the opposite party wife has clearly stated that in the first paragraph, I have last line, my lord, third line, I have recently come to know about the divorce judgment passed by this by the court on January 13, 2025, was completely unaware of the entire proceeding and was shocked from the learn of the development.
This document was placed before the learned trial judge under Order 9 Rule 13 proceedings.
This document, I have no instruction, my lord. I have no instruction. That
how could you annex the document?
I have no instruction.
The proceedings before the learned trial judge.
I have no instruction, my lord. Whether it is placed or not, I have no instruction, my lord. Whether it is placed or not. This is the document dated 2nd June 2025, my lord.
Yes.
Now the last thing is that, my lord, in oral submission, order impugned, my lord. Order impugned in oral submission.
Yes,
Internal page 2, my lord.
yes,
First paragraph 3 is the submission of the petitioner. It is last line, paragraph 3. It is further stated that petitioner wife was well aware of the pendency of the match suit and intentionally avoid the court summons. Thereafter, my lord, paragraph 4. During the course of the oral argument, learned advocate of petitioner wife submitted that petitioner came to know about the ex parte judgment on 19th June 2025. She has placed several dates, though she from her application itself, it is clear that it is 150 days delay, 150 days from the date of decree. So that is date of knowledge, and she has no whisper about the date of knowledge, my lord. So kindly, my lord, this is the scenario, my lord. Kindly allow this application, my lord.
this application under Article 227 of the Constitution of India
11 Lordship.
Yes.
The petition, madam.
Lordship, Mr. Arnab Bhattacharya is appearing for the opposite party, Lordship. He is
Who is appearing?
Arnab Bhattacharya.
Yes.
Present virtually, Lordship. That's-
Yes.
And I'm for the petition,
Petitioner.
Yes.
the petitioner, defendant, tenant.
Petitioner, defendant, tenant. Yes.
Madam, the opposite party filed a suit for eviction on the ground of reasonable requirement and defaulter. Reasonable requirement was to the effect that the suit property is required by her because she has a positive accommodation in her matrimonial home. She wants to stay with her husband and parent-in-law in the suit property. So according on that score, in the year of 2000, in the year of 2013, there was a commission in respect of the suit property.
2013 commission was held.
Yes. Now, in the year of 2019, the plaintiff acquired a flat in the ground floor.
Plaintiff acquired a when?
In the year of 2019.
2019, yes.
By a gift from her father.
Yes.
Now,
From brother, sister.
from brother and sister. Now the petitioner filed an
So
application.
what is the suit property where it is located?
It is located in Baliganj.
No.
It is in first floor. It is in first floor.
It is
So
in
it is
first floor.
flat.
Yes.
For flat, she filed a suit for requirement on the first floor that she needs accommodation because she has a lack of accommodation in her matrimonial home. Now, a commission was held in the year of 2013, my lord.
With regard to the first floor only.
Now,
Yes.
in the 2019, she acquired the ground floor by virtue of a deed of gift. Then we made an application for local inspection for the ground floor. That was rejected. So kindly, my lord, kindly read the impugned order. Because by a single order, 2 application was disposed of.
Where is the plaint is 11.
So plaint is 11, my lord. This is first plaint. Thereafter, my lord, this is the amended plaint, my
Where
lord.
is the amended plaint?
Amended plaint, my lord. This is my lord, running page 38, my lord.
38.
Thirty-eight to 53. Nothing has been stated about the acquiring of the title in the ground floor in the amended plaint, my lord.
This is flat number 3. This is in the first floor.
This is in the first floor. That is the suit property, my lord.
Yes.
Thereafter, my lord, kindly come to our rejoinder to the written statement, running page 54, my lord. My lord, kindly come to running page 57, my lord, wherein we have disclosed that on 20th day of June 2019, signed and executed a deed of gift in favor of their sister Srimati Shubhra Chaudhary, plaintiff, daughter of late Nilanjan Chandra Chaudhary, 7C Balgan Station Road, Goriatato. Thereby, they have gifted a self-contained flat, being flat number 2, measuring more or less 1062 square feet, consisting of 3 bedrooms, a dining hall, 2 toilet and kitchen, lying in the ground floor. That we need inspection. That was rejected. To prove that she has an alternative accommodation in the same building, same premises. And my lord, in the plaint, subsequently the petitioner plaintiff, the opposite party plaintiff didn't disclose that she had no other alternative accommodation. So my lord, kindly come to my local inspection petition, my lord. Points of local inspection, my lord. This is running page 68, my lord. At least point number 3 is very relevant, my lord. Just to arrive at just for a decision for reasonable requirement.
Point number
3 in my local inspection, running page 68, my lord. To draw a plan or sketch map of the present accommodation of the plaintiff number at flat 2 in the ground floor at the suit premises being 7C Baligan Station Road, Gorihat, Kolkata 19. This he has acquired in the year of 2019 by virtue of a deed of gift. My lord, this is, my lord, come to the ordering portions, my lord. So I am telling you the latter portions, my lord. By a single order, 2 application was disposed of. My lord, last page, before the ordering portions, my lord.
Yes.
No objection. Achha, sir. It is a fact that in a suit for eviction of tenant, a local inspection application filed by the tenant can be entertained by the court provided material increase in the landlord's accommodation has taken place by of new construction or obtaining separate suitable accommodation. She has got it in the year 2019, my lord.
Where is the earlier application for local inspection? Show me.
Earlier
And the commissioner's report.
Commission. Sir, I have got. Commission support.
This is my lord, commission's, I've got the certificate copy. in-
Commissioner's report.
Yes, my lord. That's it. Copy টা কোথায় গেল? It's my copy. This is my.
Where is the application for commission, earlier commission? Have you annexed that?
That is in this, my lord. On the local inspection application. Application not annexed, not annexed, my lord. I think it will be in the, it will be in the report, my lord. It will be in the report, my lord. Detailed report.
Yes. Who is for the opposite party?
Lordship,
Yes.
Abhinav Bhattacharya is appearing due to his fracture in his leg. He is not present today.
Where is he?
But
Mr. Bhattacharya, Abhinav Bhattacharya, video on করছেন না? Yes, Mr. Bhattacharya.
Lordship, in that case,
Yes.
take time, Lordship. Otherwise, I have to take time, Lordship. I have nothing.
Yes, what is your submission? Whether this ground floor flat that was inspected on the
Time, Lordship.
In the year of 2013, when the commission was accordingly held, that time the ground floor flat was a common flat.
yes, but that was inspected.
That was inspected at that time. That time, my lord, the plaintiff.
Maybe inspection was done of that flat.
But not according to the point. Where there was no point to be inspected. for
What
that-
is the point? The ground floor flat, the existing accommodation of the ground floor flat that was inspected.
No, but that was not the point for local inspection.
Maybe.
In-
Ashwin, this application under Article 227 of the Constitution of India is at the instance of the
This has been closed. The kindly liberty be given to put cross-section on the ground floor, man. Otherwise, I'll be
Cross-examine whom?
on plaintiff on the basis of the acquiring title, manner, because his crossing is over in the year as back as
That you have to take steps there, not from here. It's only the subject matter of commission. Yes, call the next matter. Yes. Yes, yes.
But my client, but initially, my lord, there is a will. In the will, my lord, I am the
What
executive.
is the impugned order?
Impugned order refusing to accept my written statement.
Refusing to accept it
I paid for time to file written statement that has been turned down.
rightly.
90 days and High Court Amendment 120 days has not been over. Not been over. Not been over.
So what?
But kindly see once.
You have a exclusive right to take 120 days.
Absolutely not.
Then
I have filed the application, I said, but kindly see what happened, my lord. But before going to the impugned order, my initially property belongs to our father. Our father executed a will. Now, my lord, I applied for the grant of probate, last line. No reason. Time expired.
I'm
Therefore,
supplying the reason.
I know that.
Where is your prayer for extension of time?
But I kindly turn to my application at page 24.
24.
24. This is the first time extension.
Oh, it's automatic. You have a right
I don't.
to apply for
I don't.
2-3 times extension.
Kindly see the date when I received the summons. But kindly see the date. I received the summons on 8 May 2025. Kindly see the next application which has been turned down. I want to bring on record the fact that in the pending appeal already injunction order was passed. That application I don't know why that has been rejected also.
What is the ground, Mr. Mukherjee, for extension of?
Yes, my ground is that what happened. All the documents were lying with the High Court lawyer.
The stereotype application, all documents are not with you. Certainly, by opening a tin box, you have got those documents.
That is in respect of amendment. That is normally we are using for amendment. By
the order impugned, the
My lord, I am for the petitioner led by Mr. Pathrupratim Roy, my lord.
Where is he?
My lord, he is engaged in courtroom number 16, my lord.
Yes.
My lord, may I proceed, my lord?
Yes.
My lord, this is suit for permanent injunction, my lord. I am the defendant number 1 and defendant number 2, my lord.
Yes.
My lord, what has happened, my lord? There is one connection, submersible pump in the name of our father, my lord. And there was...
How are you related?
My lord, brothers. Plaintiff is brother of the present petitioner, my lord, who are the defendant number 1 and defendant number 2, my lord. My lord, one submersible pump was in the name of our father, my lord, and one old electric connection was there, my lord. My lord, the suit was filed, my lord, for restraining us to use that electric connection to get connection from that electric connection to our submersible.
Where is your objection filed?
My lord, at page 16.
Page
16, my lord. That is our objection, my lord. They filed an ad interim injunction order was passed, my lord.
No. Where is your page 16?
Page 16, my lord. Annexure C, my lord. One injunction order is there, my lord. After, my lord, 8 years, my lord, the plaintiff filed application for connection from that old electric connection, my lord, to the submersible pump, my lord, which stands in the name of our father, my lord. And that was allowed without, my lord, assigning any reason whatsoever. My lord, kindly consider the impugned order once, my lord. It was only heard and thereafter it was allowed, my lord. No reason has been assigned.
I'm clarifying that it will not create any equity.
My lord,
By the order impugned, this application under Article 227. Yes.
My lord, this is my application against an order of the appellate authority affirming the order of the maintenance tribunal cancelling my deed of gift.
Deed of gift, section
Under
23.
Section 20 under the maintenance of the senior citizen act.
Maintenance clause not adhered to.
Pardon, my lord.
There was an
There was-
obligation to maintain.
No, my lord. This is an unconditional deed, my lord. There was no condition for maintenance.
Show me the deed of gift.
Yes, my lord. My lord kindly comes to page 26, my lord. 26 and the ref, at, kindly comes to my lord page 29, the reference, the important part, my lord. The
Who are
second
you?
paragraph. I am the son of the donor.
Son of the donor. Who is the donor?
Donor is OP number, respondent
That
number
I
one.
appreciate. What is the relation?
Mother and son.
Why are you fighting with your mother?
No.
Why are you fighting with? Why are you not maintaining your mother?
I am maintaining my lord. My lord, she is having a, pension of around 14,000 per month.
Maybe.
And
You
it is
do not have any obligation.
My lord, I am not against the maintenance, but I am against the cancellation of my deed of gift. My lord kindly comes to para 2 in page number 4, page 29, internal para, page 4. Para 2. There is no word of maintenance for the mother. তোমরা দানপত্র গ্রহীতা আমার গর্ভজাত পুত্র হইয়াছ তোমরা
Where is the order of the tribunal?
My lord, page 117, my lord.
117.
Running referent Reference part is, my lord,
117,
page 119, my lord. This,
119.
yes.
No, this is the appellate tribunal.
Appellate tribunal.
No, the original. The
Original is, my lord, page 109.
109.
109? Oh, no, my lord. Excuse me, my lord. It's 106. No, no reason shown for the whether this is conditional on deed of gift is not mentioned. Simply mentions that I'm not maintaining my mother, so the deed of gift is void. And it's an unconditional deed. I'm placing reliance on number of judgments, my lord. It was an unconditional deed of gift. And section 23 specifically says that a condition must be there.
Where is the latest Supreme Court decision on this?
My lord,
says even if it is not a conditional one, it can be set aside under section 23.
No, yes, my lord.
Where is that? It went from, I think, Punjab and Haryana High Court. Where is that?
Well, this is Sudesh Chikara versus Ramta Devi in 6 December 2022. My lord, comes to paragraph 12.
Yes, Punjab and Haryana.
For attracting, paragraph 12, my lord. The transfer, for attracting subsection 1 of section 23, the following two conditions must be fulfilled. The transfer must have been made subject to condition that the transfer shall provide the basic amenities and basic physical needs to the transferor, and B, the transferee refuses to fail to provide such amenities and physical needs. If both the aforesaid conditions are satisfied by legal funds, the transferee shall be deemed to have made by fraud or coercion. Such a transfer then becomes voidable at the instance of transfer of the maintenance tribunal.
No, there is a subsequent decision.
My lord, then paragraph 14, my lord.
No, I've seen paragraph 14. Where there is a subsequent decision.
My lord, I'm relying on the division bench of our honorable court, my lord. In here also, division bench of Justice Jyoti Mahapatra. Paragraph 12, 13, and 14, my lord.
Sir, there is a subsequent Supreme Court decision on this 23. I have also held in that line, but there is a subsequent decision. Have you gone through that decision? Even if it is not a conditional one, even then in section 23 it can be.
I'm only praying for an interim stay. Let the other side come, and I'll. In the meantime, I will arrange for that. I'll see for that subsequent judgment, my lord.
Deed has been declared to be void.
Yes, my lord.
Where is that?
The order of the learned maintenance tribunal.
109.
106. 106. Last paragraph.
Yes, where is the question of stay now? If it has been declared to be void.
I am appealing for the petitioner.
Yes.
Lord, petitioner is challenging an order, my lord, whereby, my lord, his right of cross-examination has been shut. My lord,
Cross-examination
of, my lord, an expert witness.
Why?
My lord, kindly seize the impugned order. This has two parts. First part, my lord, the court allows me, my lord, to cross-examine the, my lord, fingerprint expert, my lord, who has now, my lord, second part, later part, my lord, seize. Another application of the device undisposed of wherein the defendant intends to
No,
cross-examine the
for
handwriting
examination, yes, 3rd of September, for examination of official of the fingerprint
30th
bureau.
of June, my lord, order. 30th of June order, my lord.
30th of June.
Yes.
First part ordering part.
It allows my prayer.
Yes, for examination of official of fingerprint bureau.
Yes.
It was fixed on 3rd of September.
That was allowed. I'm not objecting to that. Later, my lord, bottom later. After that order, my lord, later, my lord has found, my lord, at bottom of the page. Another application of the defendant is undisposed.
Oh, that is fingerprint expert.
Yes.
Another is handwriting expert.
Yes. Now, my lord intends to cross-examine the handwriting expert.
So where is the order with regard to the acceptance of the handwriting expert report? Where is that?
Kindly takes up page 50. No, 50. No.
Page
55.
Yes.
My lord, it was sent in open envelope. It was accepted by the court. Report is kept. Report is 52.
Where is your application?
Lord, my
for cross-examination of the handwriting expert?
My lord, application has not been annexed. My lord, I have asked for that. My lord, since, my lord, other evidences, my lord, are complete. This is only left. Court says I have accepted it. I will not allow you to cross-examine. That's the finding of the court. If my lord turns to the last.
But when this report was accepted, Mr.
But that's the 8th August, that page 55.
8th of August of
2022.
2022. So you kept quiet till 2025.
We filed objection. We filed objection.
Objection is neither here.
Thereafter,
Mr. Chatterjee, you have to apply. You have to pray before the court that I want to cross-examine. That's the law.
That's my application, my lord.
Where is that?
My lord,
you have not filed any application. Where is show me the does not record any filing of any application.
my lord, undisposed of application of the defendant. Later part. Another application. It says, my lord, and another application of defendant is undisposed of.
Contested the application by filing, wherein the submits that the
my lord, order 26, rule 10, my lord, is very clear, my lord. He has to, my lord, the expert has.
Provided Mr. Chatterjee, you are prompt in praying for that. What is the stage? Argument stage?
No, my lord, not argument stage has not reached. But, my lord,
what is the stage now?
My lord, evidence has just completed. Now, my lord,
whose evidence has completed?
Plenty of evidence has completed.
Defendant's evidence?
That I have taken instructions, my lord, he will give me whether defendant has started or it has also completed. But, my lord, the stage is, my lord, evidence is complete, that's come to me. Now, my lord, what happens, my lord, order 26, rule 10, my lord, the report which comes to the court in sealed envelope, my lord, the expert has to tender it into evidence. My lord, he doesn't tender. If he doesn't tender, my lord, then, my lord,
where is the law that he has to tender it in evidence?
My lord, kindly takes up order 26. If I read it correctly, my lord, order 26, rule 10.
Yes. Sub rule 2.
Sub rule 2.
Yes.
Yes. My lord, the report of the commissioner and the evidence taken by him.
Yes.
Shall be evidence in the suit and shall form part
so
of the
automatically it forms part of the record. It's an evidence. There is no, unlike in order 39 rule 7, he has to prove his report. Not here. Unless you cross-examine.
Now, my lord, kindly see the first part. In the same day, 2 applications. My lord, court says that has not been marked exhibit. That's why, my lord, I am allowing you to cross-examine.
Where?
The first part of the order.
No, that is handwriting.
Now, my lord, on the same date, my lord, court takes up my another application and the
automatic, Mr. Chatterjee,
it's
marking
automatic.
of the exhibit, it's an evidence in the suit.
Now,
whether marking or not marking does not matter.
My lord, another evidence is left out, my lord. I am yet to, my lord, that cross-examination is going on fingerprint. That is being allowed. Now, my lord, today, if this is not allowed, my lord, order 26, my lord, allows, my lord, simpliciter filing of and he has
provided you
approach
the court at the right point of time.
My application was there. Lord, my application was there. Lord, I have a right of cross-examination of the handwriting expert.
There is substance in the argument of Mr. Chatterjee, learned advocate for the petition.
Madam,
Yes, yes, evidence service টা দিয়ে দিন।
Madam, in a suit for eviction on the ground of reasonable requirement and subletting, application under Order 6, Rule 17 was filed at the fag end of the argument. The suit was originally filed in the year 2005. Evidence concluded, arguments commenced, the defendant's argument concluded, the plaintiff started argument. At that stage, this application was filed on the ground. First time on 1st July 25, defendant obtained the document and intends to tender the same.
Yes, but it was at the some statements in the cross-examination that has come out. For that, this application
My
was
lord,
filed.
my lord. And this is for all.
What is the stage of the suit?
Argument of the plaintiff is going on.
Argument? Where is that?
My lord. In the impugned order itself, my lord will get.
It was at the argument stage. Argument of the defendant has also been concluded.
My lord.
Lordship, I am for petitioner. Lordship, expeditious disposal. My lord, I like to draw your kind attention. Lordship, kindly page 50 of my application.
Disposal of what?
Page 50, Lordship.
Of what?
Order 9, Rule 13.
Order 9, Rule 13.
Page 50, Lordship, kindly see.
Yes.
Page 50 and 51.
This is still now pending.
Yes, Lordship.
This application under Article 227 of the Constitution of yes.
I am for the petitioner, but I'll take a short pass on the ground of Mr. Shoptangshu Basu. He's leading me.
But I'll just start, Lord. Let him come, Lord, because I'll take some time. I'll take some time.
Ask
Lord,
him.
there's
Ask
some
him to
urgency.
take a short pass on his ground.
He is coming. Mr.
Because I'll
Mukherjee
take
will
some time. I'll take about 10 minutes.
Addressing in court number 10, Milord. He addressing in court number 10. He asked me to take a short pass on.
I'll take some time, Lord. I'll take at least 10 minutes, Lord, because two of the matters can be, Lord, heard by your Lordship together. 18 and 19.
Yes.
So 18 emanates from an order by which, Lord, the miscellaneous appeal was, Lord, allowed, granting injunction.
18.
Item number 18.
18 miscellaneous appeal allowed.
Allowed. And Lord, in the other one, item number 19, Lord, there was an order appointing a receiver in the suit at the instance of the defendant, my client. That has been set aside in the misappeal. Now I start.
Miscellaneous appeal.
Yes. Now this is not the scope of the matter. Now kindly come to the plaint. But first I take your Lordship to the plaint. Why it is important? Because once your Lordship sees not the scope of the plaint, the issue goes. But item number 18. Item number
30 of 2025.
Lordship.
Yes.
Page 30.
Yes.
But I am the defendant here. Now, Lord, deceased. Now, Lord, I am the suit for. Lord, suit is only for a declaration concerning, Lord, a revocation of a power of attorney. Now, kindly come to, Lord, the reliefs that have been claimed. Lord, that is at page 36.
Yes.
So it is their case, Lord, that there was a, Lord, a power of attorney granted, not coupled with interest. It was revoked by my client. My client is the owner of a particular hotel at Maithon. But he, because of his old age, it is contended in the power of attorney that he is engaging, Lord, the plaintiff here, Lord, as a power of attorney to do certain acts. The power of attorney is also annexed here. Now, Lord, I had to cancel that power of attorney, revoke and intimate. That is the subject matter of challenge here. But kindly see, my lord, the prayers that has been granted.
Yes.
It is a multifarious prayer. The plaintiff may be granted a decree of perpetual injunction against the defendant, restraining him from forcibly giving legal effect and a further effect to the invalid and illegal deed of revocation dated 24/2018 and the letter of termination dated 25/4/2018, and are taking any steps for forcibly removing the plaintiff from management and ostensible ownership of A scheduled property and entering possession therein, and mandatory injunction directing the defendant to execute a proper deed of sale in favor of the plaintiff in respect of A scheduled property on receipt of the balance sale consideration upon a declaration that the alleged deed of revocation dated such and such and letter of termination dated such and such
was for sale.
It is their case that they are running, that there was, my lord, on the letterhead a memorandum of understanding executed in 2014, by which my client, the owner, not agreed to sell the property. There is no prayer for specific performance of that contract. That is not also annexed with the plaint. Now, thereafter, my lord, in 2018, there was a power of attorney granted in 2015. The power of attorney, I'll take your lordship. That was revoked by my client and intimated. From there, my lord, he had filed the suit in 2018. No prayer from lord specific performance of the contract, but your lordship has seen, lord, the declaration that is being sought for here.
No declaration.
Yeah, only the declaration.
Injunction.
Not the mandatory injunction. Directing the defendant to execute.
Yes, declaration that it is a cancellation is
upon a declaration that the alleged deed of such and such. It is a very multifarious prayer couched in a difficult language. So, my lord, all that I take here is, my lord, that they are asking for a perpetual injunction restraining my client from, my lord, revoking the power of attorney, because there is no prayer for, my lord, a specific performance of a contract. Now, my lord, this was in respect of, my lord, a property which is at, my lord, that is at Kollaneshwari, my lord, in Bardhaman, and, my lord, they have annexed, my lord, a certain, my lord, the Schedule B and
in
Schedule C, my lord, Asansol, Maithon. It is a hotel at Maithon.
Maithon Hotel, that's the name.
Hotel Maithon.
Yes.
Then, Lord, your lordship will kindly see there are a list of documents which have been appended at page 40. In the list of documents appended at page 40 with the plaint, your lordship will find, Lord, the first 4 documents are relevant for our purpose. But this is, Lord, the copy of the defendant's 2 letter, that is my client's 2 letter revoking the power of attorney. The item number 4 is a copy of the general power of attorney, that is in 2015. And the third is a copy of the MOU dated 24/2014. And a copy of the letter by Sanderson and Morgans dated 25/4 plus annexures, that is the intimation of revocation. So these are...
He is your advocate.
Sanderson is my advocate. So, Lord, these are the 4 German documents. Other documents are not concerning his conduct of the business. So, Lord, kindly, Lord, also see, Lord, page 45, which is a notice given by my client intimating, Lord, the revocation of the power of attorney. Page 45.
Yes.
And I'm not taking your lordship to the letters. The letters are not general letters, 41, 42.
So this was on 2018.
2018. So, Lord, the power of attorney was from 2015.
Suit was also filed in 2018.
Now, Lord,
now the suit is still at the injunction stage, Mr. Mukherjee.
No, the injunction was, Lord, first of all, Lord, at the ad interim stage, Lord, it was, Lord, granted, vacated, restored by the first misappeal, and before your lordship in 227. I'll have, Lord, ultimately, Lord,
7 years in injunction. 7 years in injunction, 2018 to 20.
Yes. No. The interlocutory church. That is.
Yes.
Now, Lord, the memorandum of understanding at page 46. Kindly have a look at, Lord, the memorandum of understanding.
Yes.
Lord, this is on a letterhead, this 1 page. Why I am showing this? Because ultimately, Lord, if I apprehend that they will be arguing on 202 of the Contract Act, But this is the basis that they cannot avail of 202.
Yes. Who is the first party?
No, the first party is my client Shankar Majumdar.
You are first
And now I'm the wife of Shankar Majumdar. He has died.
All right. So you are the first party.
I'm the first party. And Ashok Majumdar is not my learned friend's client. The plaintiff.
They're the second party.
Second party.
By virtue of this MOU, Mr. Mukherjee, they have to undertake some steps, some investments. Why do you say that it's not coupled with any creation of
No,
the
my lord, it is,
interest?
when I take your lordship, my lord, to section 202, your lordship will see, my lord, that the illustration given to that particular section will, my lord, show that from the face of, my lord, the power of attorney or the document creating the agency, but interest has to be created. It is not that, my lord, from a MOU, my lord, that it makes, my lord, a agency irrevocable. So, my lord, this particular MOU in my written statement, I have said it is a creation of fraud. My lord, it was never executed by me.
This
document. Because it was executed on a letterhead. It was not registered. It was never signed by my client.
It was signed, but
I'm sorry, my lord, it was signed on a blank paper which my client had signed.
Manufactured as a
Yes. A usual story that depends on which side Mr. Basu appears.
Yes.
Then, my lord, kindly come to the general power of attorney. The general power of attorney is, my lord,
47.
Preamble 47, then 48. Because from the general power of attorney, your lordship will find this is, my lord, only to do, my lord, a certain act concerning, my lord, taking care of the litigations. Page 48, second paragraph.
Yes. 48 second paragraph. 48 is paragraph
Yes,
1.
48, and whereas due to my
And whereas, oh, I was going by number of number 2 already.
Sorry, my lord,
And whereas,
I'm just trying to cut short the time.
Yes, yes.
And whereas due to my personal reasons and my preoccupation in my family affairs, it has become difficult for me to look after, manage, control, and supervise my above property effectively from time to time, and hence this presents to do the following act. Therefore, my lord, the purpose for which, my lord, the power of attorney was granted in 2015.
So according to you, by virtue of this power of attorney, no interest was.
Because once I take your lordship to, my lord, 202 আগে সেকশনটা দে তারপরে আর্গুট আপ, but I'm equipped with the
Central Civil Extra দিন।
lordship may kindly avail of this. It's
Oh, এইখানে আচ্ছা। Yes.
No, the first is 201, my right to terminate the agency. Then, Lord, 202 is, Lord, is an exception to, Lord, the general.
Or when you cannot
Exception. Well, where the agent has himself an interest in the property, which forms the subject matter of the agency. Therefore, two things: property, subject matter of agency. The agency cannot, in the absence of an express contract, be terminated to the prejudice to such interest. Since there was no interest created, there was no, Lord, a contract to the contrary in the GPA.
So in the absence of an express contract,
if it is in, Lord, suppose a development power of attorney is not executed. Your lordship knows nowadays, Lord, that is done in conjunction with, Lord, the development agreement. Interest is created along with it. In that power of attorney, if I reserve the right of cancellation, that is coming.
Yes, that is express contract.
Therefore, Lord, there are two things. There must be an interest in the property which forms the subject matter of the agency. That is a phrase.
Agency is for that purpose.
Yes. Now, Lord, the illustration will give, Lord, an insight into what it is intended by, Lord, the legislation. A gives authority to B to sell A's land and to pay himself out of the proceeds. This is not pay himself out of the proceeds is an interest in the property. Debts due to him from A cannot revoke the authority, nor can it be terminated by his insanity. Is
for the payment of debts due to him from A.
On simple terms, if an agency is created for your own interest or recovery of your interest, I cannot terminate until unless I reserve my right to terminate. So here, and my lord, the B is also like that, where my lord, the A consigns 1,000 bales of cotton to B, who has made advances on him on such cotton. B desires to sell the cotton and repay himself. So in all these cases, the B is having an interest out of, my lord, the instrument of agency. So, my lord, now I take your lordship, my lord, to the facts of this matter. Now, my lord, I was at page 48 of the General Power of Attorney.
Yes.
Now, my lord, 1, 2, 3, 4, 5, 6, all are, my lord, concerning litigations. Nowhere your lordship will find that any clause is devoted to that, my lord, the power of attorney holder is entitled to, my lord, appropriate any money out of, my lord, the property which he has been entrusted to manage.
No, where is that? You started by saying that you have appointed him to run the business. Where is that? Here?
That is, my lord, in my pleadings, I have said that he was a manager of that particular hotel.
No, not by virtue of this power of attorney.
By virtue, power of attorney is, my lord, that he is running the case of, my lord, based upon two things: the MOU and, my lord, the power of attorney. And, my lord, since I have revoked it and intimated, I admit that there was a power of attorney, not the MOU. And, my lord, it was in my case in the pleadings that he was appointed as a manager. Now he is trying to, my lord, create documents and assert, my lord, the right of ownership. Now, my lord, in this context, my lord, the GPA doesn't, my lord, on the face of it, does not confer any interest appropriable by, my lord, my agent. Now, my lord, page 85 is the injunction application filed by them. But the prayer is at page 86. The plaintiff therefore prays that your honor may be pleased to allow this application and to pass an order of temporary injunction restraining the defendant from forcibly giving legal effect and a further effect to invalid and illegal deed of revocation dated such and such and the letter of termination dated such and such, and or taking any steps for forcibly removing the plaintiff from management and ostensible ownership of a scheduled property. There is no case of ostensible ownership made out anywhere. Ostensible ownership is running contrary to his case.
So where is the order of the appellate court, order of injunction? Please take me to that.
But I will just note the ad interim injunction that was granted is at page 96.
Not the ad interim, please show me the, now you have the contested injunction by the appellate court.
35 probably.
But one.
No, Mr. Mukherjee, you are challenging the contested order of injunction by the appellate court.
129.
129.
129, wherein the injunction was revived. It was vacated on contest.
All right. So this is temporary injunction. Appeal against temporary injunction.
Temporary injunction.
No, the injunction was vacated.
Ad interim or temporary. Oh.
Now only from the ordering portion at page 133,
Lordship,
there are two aspects.
Lordship.
One is restraining you from giving effect to that deed of revocation.
That is allowing
and the termination.
That is allowing the suit at the interim stage.
And another is from interfering with the possession and management of the such and such in respect of such and
No
such.
case made out or relief print.
No,
on
but
that.
your case is that you have engaged him as a manager to run and control the business. So admittedly, he
Manager,
was,
it is a case of service. It is not, my lord, a manager, my lord, I give him any right to manage in a sense, my lord, that he has a right or interest in the property. Now, all I say
there are
is,
two things. Mr. Mukherjee may not be, he has an interest in that immovable property, but he was permitted or he was in possession or in control, if I can put it in another way, in control of that business.
as my agent, not in his individual capacity.
Yes, yes, as your agent. But he was running because, please show me the plaint averment with regard to this case.
Lordship, yes. Kindly come to
And
page.
your, or the injunction application and your written objection.
Kindly come to the plaint, the main document, my lord, because the injunction application is almost, my lord, a copy
Yes,
paste
please
of.
show me with regard to this running of the business only.
Lord, page 31, paragraph 3.
Yes. Yes, so paragraph 3 is their case.
Lordship.
What is your counter case?
Then, Lord, 4, 5 also. Kindly see, your lordship was.
Yes, 5.
Five
Running, managing and operating. What is your counter case?
Yes.
Before going to 5. 4 also.
Yes, 4 is supplementing 3. You said that you are allowed to do this and you have done that. So 4 is supplementing 3 that you have done those.
I said it's a
5 is with regard to the control of the business. Now, what is your counter case?
Yes, that is, your lordship will kindly come to, my lord, the written statement at page 97.
A written statement or a written objection?
Or if your lordship requires a written
because
objection.
it would be better because I cannot go into the written statement now. The injunction application, same allegation, same paragraph.
No, no, my lord.
Nothing to the objection 106.
106.
106. Usually these are stereotyped, same paragraphs. Maybe 1 or 2 paragraphs.
No, only 2 paragraphs are there. Nothing is there.
Injunction
The
application.
injunction application, it is in the page 80.
Objection to the injunction application.
No.
106, 107.
No, injunction application.
Injunction is at
the
page
veto
85.
of the plaint. Page
85 is the injunction.
No, this is also not ditto of the plaint, Mr.
But, that's the reason, Lord, I took your lordship to the plaint because, Lord, the main prayers are contained there.
I follow that, but Mr. Mukherjee, while deciding the injunction application, can I go to the written
Very well, that's
statement?
not, it is their injunction application. Very well, that is to my advantage. Very well, then your lordship kindly
Alright,
see the averment.
take me to the written objection.
Then, Lord, kindly see, Lord, what that they have stated in the injunction application was, Lord, paragraph 3 at page 85. They are not banking upon, Lord, only the question of revocation. Paragraph 3, page 85. Then paragraph 4. Then, Lord, paragraph 5 is the prima facie case. Nothing more. No pleadings.
So, Basu, what sort of injunction application?
Only paragraph 2 can help you. Only.
Paragraph 2 is
Can help me.
grave leave to treat.
The Plaintiffs' Environment Act, part of this injunction.
Very well, your lordship goes by.
He has to
Then
rely upon his written statement, Mr. Basu.
He has to. I cannot stand in. If this is the this is the nature of injunction application, so I cannot restrain your lordship.
I allowed Mr. Mukherjee to place the plaint because I was under the impression
Because
that
I was also not trying to apprise your lordship about the real dispute of the parties.
already
That's
then you
the
can place your written statement.
I cannot.
The counter case of this.
So, Lord, my point before your lordship as of now, that, Lord, the injunction of the nature that they have asked for is not the revocation is to be kept in abeyance. The effect of it is, Lord,
Finally,
there is an
in the
agency.
suit.
That is one. In the interregnum, Lord, they are unable to succeed in the suit and mismanage the property, Lord. It is irreversible. That's the reason, Lord, there was appointment of a receiver in the property, which is the subject matter of the next application.
Receiver is the third party receiver.
Third party advocate receiver.
Take
Advocate
that
receiver.
matter. I'm ready with that matter. I'm not fully
You're not ready with this matter.
Fully not ready, but in that matter, if you have to
আরে
stay, I
একই
can.
তো ম্যাটার তোমার একই ওটাতে খালি একটা order 40 rule 1 আছে আর
এটাই তো আসল।
How much time both of you will take?
but I will take another 10 minutes but this is important. Why I say this is important? Because Lord, they have given a letter after the misappeals order is concerned, the receiver to hand over possession to them.
Only because I was
And today at
trying
3
to
p.m. This is not the letter. That's the reason I'm bothering your lordship, Lord, so much. And otherwise, I would have mentioned it before your lordship.
Because
It
yesterday's
is not.
matters
I understand.
are also there.
I understand. Now, Lord, the receiver was continuing in the
Asu is
property.
responsible for that.
Whatever bad things in High Court, I am responsible. Don't do everybody.
No, no. The good 1030 things, you are also responsible for that. এখন আর যদিও পারছো না সেটা
না করছি না কারণ এখন খালি পলিটিক্স ছাড়া কিছু হয় না সেদিন আমি আনি যেটা করতাম তখন
Yes, Mr. Basu, what do you say to this? Because it will take some time to hear this.
But the
this is
receiver
your
should
letter.
continue, Lord, as
This
of
is your
now, because
letter.
I cannot allow him, Lord, to.
yes I have seen that letter.
Yes.
I was in possession. I was in possession.
So, no, it is not his hotel, first of all. Lord, I can show from the document. If he says that it is his hotel, then he is giving up, Lord, the question of MOU.
No, that
Then he
is-
doesn't have any plaint case at all.
I know that.
But
What
if
is
an
plaint case?
employee of a hotel comes and says that it is my hotel, or if he was
what is my
bestowed with
case?
Lord, the charity
I was
running a
only,
hotel.
Mr. Basu and Mr. No, I was only thinking if I can post it on any other day, fixing some time. That
Then,
is why only
then
for
an
that.
interim order is required as of today.
That is why if Mr. Basu, you say that you will not act on that later, then otherwise I have to proceed with this.
I am explaining the difficulty. A third party receiver has been appointed.
He
It's a
has
running
not
business.
challenged that. He has not challenged that.
That has been challenged. That's why it's
He
altered.
says that Lord, appointment of a receiver has been a subject matter of challenge.
On the both score.
This is the letter addressed to the receiver.
Yes, by my learned friend's client.
Yes.
By the receiver saying
Can you wait for, Mr. Basu, can you wait for 1 or 2 days?
2 days.
Some days. That is why I am asking you.
Days more will be
Closer to the
closer to
vacation,
the vacation, more will be difficult.
more will be
Yes,
free.
but
Mal will come on Saturday. Then Mal will come on Saturday. That I will not.
if you want, I can. No, only because motions are there. Otherwise, I will.
This is also motion.
It will be.
But I can say, Lord, I'll be taking, Lord, another, Lord, 15-20 minutes of your lordship's time.
The other matter is there, Mr.
Other matters are-
Mukherjee. Receiver is there. Mr. Basu has to be heard. Some point you have to give your reply also. That's the thing.
Only difficulty is now it is festive season. In
Now
lawyer
is-
can- festive season in the hotel at Maithon. The lawyer my lord, can run.
No, he was not running it. He was entrusted
Basu,
with the accounting.
Basu, when the appointment of the receiver was made,
That is my lord.
2020.
2020.
and he
So,
has been moved
sorry,
only
2021.
now. So for 4-5 years he was running. 4-5 years he was running. That is why I'm asking you, can you not allow the advocate to run for one more festive season? He has run for 4 festive seasons.
Just a minute. No, I will ask my client not to press this letter for the time being. You don't pass any order.
No, I'm not passing it. If you say I'm not passing any order,
Yeah, without any order, my lord, I'll be at the lurch.
Mr. Mukherjee, Mr.
Then
Basu,
kindly
they are
record his submission. Then kindly record the submission. I believe Mr.
recording
Basu.
your submission.
But his submission
Alright.
should be recorded. At least something should be there, my lord, to
I'm recording
impress
that
the
since the
learned.
matter is being heard, you will not press in the meantime.
Yes.
Guys, Hagna, don't press your letter.
Since the matter is being heard, I'm
Lordship. I'm sorry.
Okay,
Me, I can ask the learners.
Yes, ask him. Yes.
Item number 20.
20, yes.
The 20 is Milord expeditious disposal of this suit. What mentioned in item number 403.
403, yes.
Milord, this is where Milord I gave an undertaking. My Milord has recorded in 403 to furnish me an undertaking in the suit filed by Milord, my learned senior friend's client, where I was evicted. Milord, this I was the tenant in 403.
Yes.
So, Milord, I have passed a decree, I have suffered a decree of eviction. I give an undertaking that I will leave the tenanted premises within a span of 6 months. For that, Milord, I have agreed to pay the occupational charge.
Yes, you have to file the affidavit of.
Yes, Milord, that is with me in 403.
Yes.
And this 20 is, Milord, my suit for eviction, Milord, for which I am seeking that 6 months time give me in that period.
Where is that? Where is your other side?
I have informed Milord, Chamul Chakraborty was the other.
Where is he?
I have informed Milord to come at 2 Milord. Milord, kindly keep undertaking the then. Undertaking this is the undertaking, Milord.
But unless he comes, let him come. Yes.
But then kindly keeps it because client is here with the occupational charge as well, total for the 6 months.
All right,
I will hand it over to him.
Inform, mention after Mr. Chakraborty comes.
And
on this application under Article 2. 7172.
Yes, that's why, Milord,
long way to go, Mr. Chatterjee.
That's why I say, Milord, unless a direction, Milord, I'm giving
7172 pending.
Pending. Suit of 2021, but COVID.
What is the next date fixed?
Today was the
otherwise ready. Objections filed.
Yes, Milord, today was the date for hearing of 7172 last order.
Today is the date fixed. What happened today?
Milord, today yet to be informed by the learned trial courts.
This application under Article 227. Let it proceed to some extent. 21.
Sir, Milord, 15 was.
Who is appearing in 21?
21.
So, Manager, yes.
Lord, the point is, Lord, my two suits were filed and one probate case was probated on contested hearing. Probated on contested hearing. But Lord, certificate, before the certificate was issued, Lord, executor died. Only the ministerial act is to be performed for the purpose of issuance of a certificate. That is why we file an application for letter of administration. Letter of administration on contest on contested hearing issued. Number issued in 2018. 2020, the application under 263 was filed. First of all, maintainability at that point, your lordship was the architecture of the whole similar.
I was the architect.
Because of the Supreme Court judgment. And the judge was the architecture, your lordship argued the matter. No, don't take that point.
What I have argued at that point of time?
Yes.
I've forgotten everything.
Yes. Now, my lord, that we shall take it. Now, my lord, two suits. One suit was filed for declaration of title and injunction against the contesting parties in a probate suit. Now, my lord, that was the state till the disposal of that probate. Now, my lord, ultimately revocation of the probate. Now, Lord, ultimately, Lord, in one suit, because suits filed, first suit, declaration and permanent injunction. Second suit, in violation of the injunction, Lord, transfer was made. Therefore,
Declaration that the deeds are void.
Deeds are void. Now, Lord, with regard to the first suit, Lord, that has been with regard to the first suit, and that Lord, stay was granted. Stay was granted on practically on consent that that the letter of administration is pending. Therefore, let it be a state. With regard to my lord, that is another suit that is for recovery of possession. That is, my lord, we rejected that application. We said stay may be granted till the disposal of the not probate letter of administration.
No, letter of administration granted. Now the revocation.
Only
Revocation after revocation was filed, it has been stayed.
Yes.
No, stay application, Mr. Banerjee says it has been rejected.
Rejected. Practically, my lord,
the question is, I am for the defendants.
I am opposed by the judgment of your lordship.
I am opposing this application. But the question is this: he sued filed against me. He got an injunction in the trial court there. Now, in that suit, the will complained of is not the will which my learned friend is saying. I have a copy of the plaint. I have the copy. This plaint says the will is separately other will. This is not connected with the will in which revocation and the probate is continuing. Well,
there is one will. They have filed
I can show from this.
They have filed objection. There is one will.
Well, I can show from his petition that these are separate.
No, that is wrong, my lord.
Well, I can file from his petition filed by the.
Give me a minute. Give me a minute.
The Kashinath Mandal is here. Well, at Kashinath Mandal application, I shall show.
Lord, page 40, your lordship kindly look
last
to.
page, last paragraph, kindly see that you will cover, my lord. Page 148, I think.
Where is the impugned order?
Impugned order, impugned order 148, you will also kindly see. Court has said why he has refused it.
Lord, he misinterpretation and misunderstanding of the facts. There is one will. And he has filed objection and saying that there is one will.
Not one. 3 wills.
No. There is one will.
I can show from his petition.
There is no 2 wills.
Page 149, well, last paragraph, you see. It's quite clear, this is written, that the revocation suit has been filed such and such.
Date কবে গো? Will date.
Oh, there is another unregistered will.
Yes, another unregistered will. Another unregistered will.
No. One will, my lord.
I can
Practically, in my plaint, my lord, mistakenly it has been stated as a registered will. But there was no registered will.
But
we
took registered will, Mr. Banerjee.
Lord, we took
will from other, from Manipur.
One is unregistered will, another is registered will.
No, 2 registered will, one from Baripur.
Lord, that, my lord, I took, my lord,
the will. 93 is of Baripur. Well, I have a copy with the plaint with me, his plaint, and he has got the injunction against me. Now he is saying that I cannot continue with the suit be stayed. But my submission is this: so let his suit be continued, lest it be decided.
Now, my submission, my lord, before your lordship is this: that the will that was provided in respect of the identical
Where is the plaint of the
schedule.
93 of 2014?
I have with the copy of my plate with me. I have my copy.
Have you annexed, Mr.
No.
Banerjee? 93 of,
This is not annexed.
please.
Yes, my lord, I am giving. I have put the copy. I have the copy, my lord. এটা তো এটা প্লেন এটা 93 পেজ কত 93
93.
It has been annexed. No.
No, my lord, it has not been annexed. I have gone through the entire petition. It has not been annexed.
No, my lord, I am giving that.
Where is
কোথায়
that?
গেল এটা
My may I submit
93
my copy, my lord?
yes, my lord, this is different. Lord, in my that in by mistake, my lord, it has been mentioned as registered will. But date is there. And one lord will in respect of one unregistered will. I took a probate in respect of unregistered will. I took letter of administration in respect of unregistered will. The suit in respect of the blood in two suits, scheduled property in terms of the unregistered will.
That's my lord, I can.
And he has taken advantage, my lord, of my plain.
But there is no appeal.
No.
Will is there.
Please,
All will is.
kindly allow me to say. In my plain, mistakenly, we have
Paragraph
said-
7, you also kindly see.
Yes.
Paragraph 7.
mistakenly we have said,
Paragraph 7.
yes, kindly, that registered will. Now, what is his defense? His defense is there is no existence of the registered will. That is his defense. Kindly come to his
Not
defense.
my defense or that, or not only that. It is a completely separate will for which
No, there was no
93 has been
separate.
filed. Now, my lord, kindly come to page 63 of his. Of the
Lord,
of
kindly
the
look to
petition.
their witness statement. He took advantage of the my mistaken registered will. One will, and that will was contested, probated.
Well, paragraph 8 has been wrongly stated. Paragraph 7, I shall.
Your case is that there was no registered will.
Mr. Banerjee, this is the specific finding that the revocation
Lord, that
case
finding is wrong.
against a separate document.
Yes,
Lord, that is
separate document.
perverse finding. Lord, he in isolation he read this. Entire if the entire plaint is read, my lord, my practically declaration of title based on a registered.
What is the
will.
next date fixed in the suit?
Lord,
15.
What is the
I
next
think,
date?
my lord, 15. I think, my lord, 15th of this month. 15th of this
15th
month.
of this month.
15th of this month.
Yes.
Now, you before that, you'll also kindly come page 63 once of the
63.
application. Application, it will clarify his application. You'll also kindly see in OA suit where the revocation and probate has been granted, page 63 once. This
Yes.
but the cost title, you also OA suit number 22 of 67, in which but the probate has been granted. Now, we'll also kindly see who has filed this application, Mr.
Nirmal Kumar Mondol.
No, Nirmal Kumar, Kasinath Mondol.
That is
Kasinath Mondol. Here is
Executor
Kasinath
same.
Mondol. Now we'll also
executor same.
Kasinath Mondol. Now we'll also kindly come to page 3, paragraph 6. Page 3, paragraph 6 of Kasinath Mondol's pleading. I am reading, my lord, that the petitioner, only legal heir of the plaintiff, are hereby undertook to make a deposit of rupees 50,000
Yes.
valued judicial cost.
Registered will.
Registered will where? From Alipur 24 registered on in separate will.
No, there is no will at all registered.
No,
But Mr. Banerjee,
Yes.
this is the
registered.
Lord, I tell your lordship, the will, my lord, volume number.
Another he has, after that, he has filed an application here in this 93 suit that no, I am not asked for registered will, unregistered will. You know, so that application is also
No, will was prohibited.
Therefore,
My whole case is
93 suit is completely different. He is showing that he has got an injunction. Let the injunction be vacated, that the suit be sued or stayed or dismissed. I don't have any objection. He has got an injunction against me, and he is saying that now after getting injunction, I don't want to proceed with the suit.
Lord, judge,
I am
that
dependent.
degree, I can
That his suit
I
be
can
proceed with-
produce before your lordship only one in volume number 4 in the diary, my lord. It has been mentioned by the
Volume
client.
number 4, no will
Lord, on the
be there.
basis of that mistake.
Money
So
FIR
for
has
1
been-
minute, kindly throw that will. Kindly show that will,
Which will?
registered will. You are saying
There is no
registered will.
registered will. But I
There
have
is
lodged
no
an
registered,
FIR.
only one.
Well, I have lodged an FIR.
There was no will at all. One will.
In every
One and single will.
that the Alipur registered.
And I am claiming on the basis of that date.
But the probate, that's why the probate has been broke. But
No,
FIR.
where is
No,
the
that
reference?
is
Mr. Banerjee, where is the reference of the probate here in this suit? Which paragraph?
Well, only this, well, I have gone through only page 66, it has been deferred. Nowhere. Nowhere. His application, his thing. And on this application, 50,000 has been granted. And
the letter of administration was not granted. That is why there was no reference.
The application, his reference is the.
First of all, probate was granted, no formal certificate was issued. By this time, he died. That is why letter of administration.
But that is
in contested hearing, my lord, it was
asking for a will
in
No, Mr. Banerjee,
2018.
what is the effect of that probate on this suit?
Blood effect
Nothing.
of that probate in that suit in respect to the property which is covered in my plaint.
No.
If the probate is revoked, who will get this property?
Blood probate is blood, then in that case,
My client 50%.
50% we are claiming 50%.
And if the probate remains,
If the probate remains, then
He
entire,
can enter. He will
entire.
enter. And he had got an injunction against me.
Then my lord, my suit will be
Knowing that
dismissed.
Baripur will is
My
there.
suit will be dismissed. I will not be able to prove my case.
Let the injunction be vacated. Then I will
Basis of the will.
where is the injunction order?
My injunction order, you will also kindly see at page 30.
The injunction was on what ground?
On what injunction was done, I am forcibly entering the premises. But my
And below transfer has been after the injunction order was passed.
but the
Showing that the injunction is subsisting.
All right.
That is why we wanted to get injunction.
Yes, please come tomorrow. Heard the learned advocates for the respective parties. Mr. Banerjee, please take it back. Please bring a copy of the fresh plaint. এটা দিয়ে দিন plainted copy টা. Yes, call the next matter. Yes, who is appearing?
দুটো প্লেনটি আমাকে দিয়ে দাও।
My lord, I am appearing for the petitioner. I am praying for not today.
Why?
My lord, my senior is engaged in another court.
Ask her to come. This application under Article 227 of the
he was appearing in the first half, but he's some personal difficulty. He had to go back. Well, I'm just praying for an accommodation, my lord, for a few days' time, my lord. Just a few.
7 to not within time. This application under Article 220.
Madam?
23-24, same order.
My lord,
Yes.
my lord,
Call the
with
next
your
matter.
lordship's pleasure, my lord, to take my lord, because both parties are same, my lord, same proceeding. My revision is item number 39 and 40, my lord. I have also challenged this, my lord, because
39 and 40,
Very
please
good.
allow me to proceed.
Item number
Because there are others in front
My
of
lord,
you. Yes, please.
Item number 403, Mr. Chakraborty is on the other side.
Yes, call the next matter. So 403 is that affidavit. Yes, Mr. Chakraborty.
No, we have filed it before, my lord.
Mr. Chatterjee, you have to serve it upon him.
Copy this.
Not today. Please. Tomorrow. Please serve a copy upon him.
Can I copy give me?
Why have you not served a copy upon him? You have to
I
take
shall
up
hand it over
whether
right
his affidavit was in consonance with
Sir,
his
this is one
direction.
affidavit, my lord. I will leave it by that day, my lord, and I will pay the money here and now. My undertaking is, my lord, I will leave it as recorded in my lord's last
You
order.
pay it today.
Today
Mr.
itself.
Chakraborty, they will be paying today.
My lord, I am
I am not agreeable to accept the payment.
no, payment is, my lord,
Take it,
nothing,
take
my
it.
lord.
If you are ready with the bank draft.
I have given the
The
bank.
cash, I am carrying cash. I give him cash. 30,000, my lord, I am giving cash.
Yes, Mr. Chakraborty will receive cash.
No, I have not. He has not paid.
What was the direction?
My lord,
Not inside.
my lord, the direction was,
What
my
are you
lord,
doing?
last order was, my lord, by.
Direction was by draft or what?
No, my lord, there is no more thing.
Bank account.
My lord said if I want to pay through NEFT, then opposite party numbers through bank.
Please pay it to the bank account, Mr.
I-
Chatterjee.
bank-
I'm keeping it tomorrow. Please pay it to the bank account.
Pay back.
Mr. Chakraborty, please furnish the particulars of
I have
the-
already
Yes,
given.
that he has furnished.
Please transfer it to the bank
My
account.
lord, since, my
tomorrow.
lord, I was paying it entirely for all these months.
Maybe this amount, please pay it to him. Please give a copy.
My lord is keeping and making not today.
Not today, tomorrow.
Let him, my lord,
Give a copy to him.
Yes, my lord, I am handing
as per the order, my lord, he was to file, my lord.
By today?
Copy.
Yes, by today. That's what
আচ্ছা
the
তাহলে একটা
direction.
order record করে নিন।
Yes.
recorded that you are filing.
Undertaking file be recorded.
It-
Undertaking file
25
it has been recorded. Undertaking has been filed by him.
Yes, yes, I have recorded that. Record করেছেন তো?
Because
Undertaking
my
filed in court. 25 রাখবেন। ওই
এটা কত টাকা? There's a passover matter, item number 15, passed over.
Passed over is
Passed
passed
over means, my lord, since the other side was not here.
Alright. He has come.
She has
Please
come.
wait. Please wait. Yes.
My lord, I appear for the petitioner. This is that matter where, my lord, we tried to, my lord, go before the, my lord, state commission. It's not happening. My lord, kindly considers, my lord, takes the CO, my lord, because I have to, my lord, indicate from the CO the facts in brief.
Alright, so where is the transfer application? Show me the Mr. Kaur, are you opposing the transfer application? I'm transferring it from here.
My lord, my prayer is,
I'm transferring it from here.
no, my lord, it will not happen again.
Why?
My lord, lordship had, my lord,
No,
recorded.
it's transferred. I directed the transfer application to be heard. They are saying online it cannot be filed. So I'm allowing this. The matter will be transferred there.
From Asansol to state commission.
Yes. Principal bench. Where is the difficulty?
Not accept filing.
I am told by my instructing advocate that the filing will not happen even after this order. There are, my lord,
will not happen.
It will not, my lord, they are not cooperating. My
Let
lord,
them file for contempt.
Filed. My lord, the records are there in Asansol.
Article 227, your lordship will exercise the power, my lord.
No, transferring, he says, even then it will not be accepted.
So, once the High Court transfer the proceedings.
My lord,
from-
once the High Court directed, my lord, last 3 orders, we expected the state commission to act in terms of these orders.
Let me see this time. Where is the application for transfer?
Transfer application has.
There is, my lord, it's not annexed. I have a copy of the transfer application.
Could not be filed.
Could not be filed. Copy আছে?
So, Mr. Chatterjee, you are appearing for whom?
With Mr. Kaur, my lord.
Oh, that is why you are keeping mum.
Yes, my lord. But I say, my lord, it is disposed of, my lord, Mr. Kaur would say, I not me.
What?
No.
Kaur is there, my lord, I can't.
We are not taking. He was trying to say that in a disposed of application, this application has been filed. No, where there is a difficulty in carrying out the lordship's order, this
Difficulty, sir. If they do not do, contempt will lie. Contempt will lie. File a contempt.
Mr. Chatterjee, yes, contempt would lie, but that will not solve the problem.
And it's not healthy also.
Yes, because
Lord, my senior doesn't want to do it. I am the last person to say anything else.
expression. That is why, because Mr. Shane on the application said violation. That is why.
So now, if they do still
Yes,
accept,
yes,
then that's a
that
different
is
consequence.
Mr. Doctor for the petitioner submits that in spite of a specific direction passed by this court RP 18 of 2024,
Yes.
along with connected applications from Asansol to the principal bench.
Yes.
And next is fixing a date that has to be done by the
Lordship has
commission.
also considered prayer B.
Yes, now prayer D says hearing of
B
the,
for Bombay, my lord.
yes, B is that transferring the entire record.
And of appeal and petition revision.
No, B does not say appeal.
Yes, my lord, I don't
So,
know.
and appeal also, yes, yes. And appeal also, as well as the connected applications.
Yes.
Then C is for fixing a date that the principal bench after transfer will do.
It is only restricted to B that your lordship is considering.
Yes, only restricted. Fixing will be by the.
No, my lord, I would request your lordship to kindly make a direction for fixing, my lord. Kindly, lordship has seen my plight, my client's plight.
Doctor, I cannot fix a date from here.
No, I am only saying one observation from your lordship will help me, my lord, move this before the vacation.
There be both to be transferred.
Yes, with all papers, including
Connected applications.
That's
Ashwin. Kiela?
He is enjoying a blanket stay, my lord. I cannot recover
enjoying a
tariff.
blanket stay.
Blanket stay he is enjoying.
Paragraph
But he is also withholding my 50 lakh.
My lord, one correction in last day's order. This is, my lord, 2nd of September 25. Instead of affidavit of service, it should be supplementary affidavit.
Supplementary affidavit of service.
Supplementary affidavit. We filed a supplementary affidavit in the CAN application. So
Order
it has
dated?
2nd of September. It has gone down as affidavit of service.
Oh, Mr. Dotto. Call the next matter.
15, my lord, I am appearing for the petitioner. My lord, we have informed the
Yes.
other side, my lord.
Where is he? He has come.
My lord, my lord, Mr. Sukumar Bhattacharya's daughter has been instructed. She was there.
Where is she?
কোথায় গেল? Oh, তুমি তো instruction পেয়েছো। Now she has received instructions to appear.
Yes, আবার আসবে।
ও সুকুমার কাকা নেই? আচ্ছা না না সুকুমার ভট্টাচার্য's daughter
আসবে না কিছু। Yes.
Yes, my lord. She has received instructions.
Yes.
AOR for this matter is not well. She's not come to court today. My lord, kindly keeps the matter tomorrow.
Who is the advocate on record?
Devdatta Manna.
You are appearing
My lord, I received the brief just 1 hour ago.
1 hour ago. Then Mr. Chatterjee, she has to be given 1 day.
My lord, I have no objection. My lord, only problem is that if this matter goes down, my lord, I lose a chance. My lord was satisfied with my right of cross-examination. My lord, I have taken specific instruction. Cross-examination of the fingerprint expert is fixed on putting on requisites for summon is in November. So my lord, evidence is going on. So my lord, at that stage, my lord, today my handwriting expert cross-examination is stopped just because it is being accepted by the court. My lord, then this right goes. My lord, then today, my lord, kindly protects me to that
The
extent.
junior member of
My
the
lord,
court,
I
can you
understand.
not give her 1 day time?
I have no problem. Kindly do not let this matter go down.
1 day you are also in her position.
My lord, kindly do not let this matter go down. My lord, if it goes down, my lord, then
Above in the High Court at Calcutta.
my lord, that kind of protects me for a limited period. If it goes down, my lord,
Tomorrow রেখে দিন. Yes, call the next matter.
আমি উপরের দিকে রেখেছি।
Yes. কিসের জন্য?
তাহলে সার্ভিসটা রেকর্ড না জমা দিয়ে দিচ্ছি।
25 কিসের জন্য?
Was filed in connection with this CO.
Application?
Yes.
Why it is to be mentioned?
The lower court is not in session, and since 2024, the order had been passed.
You are appearing for whom?
For father.
But this has come for correction only. 27. 27. Yes, what is the Bostacky?
Perhaps, my lord, I think the full name has not got down. It should be
Bostacky.
estate of Sri Nityananda
ঠিক আছে?
Trust.
Bostacky. Yes, next.
I'm grateful.
এটা দেখে নিন। Yes.
I'm for the opposite party, my lord.
Yes. Why it is appearing under the heading for orders?
Because cross-examination by video conference was turned down. I preferred this revisional application, my lord. Your lordship directed me to persuade my client there. He is staying in US. He persuaded, my lord. Then he has got a act second. He has got a holiday of 15 days, my lord. He is coming on 17th till 1st. Next date is fixed on 19th. So if that can be completed, everything goes, my lord.
He is coming from.
Well, only one point that troubles me, that rule 6.2, as mentioned by the learned court, that a discussion with the other party.
Rule
6.2, page 44.
Video conference.
He is physically coming.
Yes, he is physically
Then no matter.
He is physically coming.
The matter can be disposed of, my lord, if on that date, my lord.
Rules for video conferencing. Yes.
Because your lordship told me, my lord, I persuaded
That
him.
is the issue, my lord.
He has taken a holiday from the next year. He is coming.
Because these rules have not been notified. Rules has been notified, but when it will be coming to force, that is yet to be notified.
Your lordship
Now,
said on the last day, it is very cumbersome.
No, this rules is expected to be superseded by another rule very soon. Ashun.
My lord, for extension of the interim order, I am appearing on behalf of the OP number 1, my lord.
Who is appearing for the other side?
My lord, I am OP number 1.
Yes. What is the impugned order?
My lord, initially, my lord, the
What is the impugned order?
my lord, my application for sending the my lord, agreement for impounding before the registrar, my lord, that was turned down. Initially, once my lord, it has been turned down, I came up before this honorable court. This honorable court set aside the order and directed the matter to be remanded back with certain observation.
Last page, my lord. Kindly see.
Page, my lord,
So now the interim order is still in subsistence.
Yes, it's still the my lord,
The matter is appearing in the list.
Yes,
The main matter.
আচ্ছা, list
হ্যাঁ,
টা জানো?
হ্যাঁ, ওটা monthly list ছিল তো। Monthly list.
Monthly list.
Matter running in the monthly list, matter.
After hearing the learned advocates for the respective parties.
Party, my lord.
Yes.
Madam, I am appearing on behalf of the petitioner, my lord. This is for extension of my interim order, which has already lapsed on 31st January 2025.
It expired on 31st of January. February. Why did
31st of January 2025. I am praying for restoration of the interim protection. My lord, the impugned order was that the landed first appellate court below has disposed of allowed an application under Order 41 Rule 27, keeping the main appeal pending for final consideration.
Cannot be done.
My lord.
Cannot be done.
My lord, may I just indicate this, my lord?
That is the impugned order.
Order 41, Rule 27 was allowed. My lord, that was, my lord, against that, my lord, my learned friend had come up after 1 year. My lord, the appeal has been stayed. Because it had come up after 1 year, my lord, in the meantime, my lord, it was remanded back to the trial court and the additional documents has already been tendered into evidence and the matter has gone back to the appeal court. Now, my lord, what are these additional documents? The suit was for eviction, my lord, under the West Bengal Premises Tenancy Act. Every issue was...
Where is the impugned order? What is the impugned order? Page?
Yes,
What is the date of the order?
My lord, impugned order, my lord, will find at page number 66.
September 2023.
16th September.
September 2023.
My lord, page number 66, it has been...
16th September 2023.
My lord.
This is the appeal has been disposed of.
No, my lord. The appeal was kept pending, my lord, and because the additional evidence was required to be recorded, my lord, for that limited purpose, it was remanded back to the trial court. That exercise has been completed and the matter has come back before the appeal court. Now the appeal is pending for final hearing, my lord. My lord will kindly see the operative portion of the impugned order at page number... My lord, 83, my lord. That's the operative portion. My lord, the additional document that I intended to use, my lord, was an authority to institute the suit on behalf of a company. In the trial court, my lord, every issue was held in favor of the plaintiff, except for the fact that the suit was not held to be maintainable because the authority was not proper.
My lord, it is not a case of whether they have a good case or bad case. It is a simple case of whether an application under Order 41 Rule 27 can be disposed of, keeping the main appeal pending for final consideration. SAU.
Yes. How can this Order 41 Rule 27 be taken in isolation with the hearing of the, where is the decision?
May I just indicate, my lord? I absolutely understand that if my lord is sitting in appeal and there is an order 41 rule 27 application, my lord will hear both the appeal and the order 41 rule 27 only for the limited purpose to see whether the documents that is sought to be introduced is actually relevant
So
or
that
not.
cannot be decided
if it
unless
is not,
the appeal is taken up for hearing.
now my lord kindly sees what documents I am putting in, my lord.
Whatever may be the whether that are relevant or not, that cannot be decided in isolation. Sir, where is the decision? You have not brought that.
Kindly hears me out for.
My lord, I have one authority, Union of India versus Ibrahimuddin.
What is the citation?
My lord kindly hears me out for 2 minutes, man.
The India Kanun app, there is.
India Kanun.
Today is
Think
fixed for extension.
89 CLJ or so.
My lord, I absolutely understand. I am not denying that proposition. That is because that both has to be heard together, and the purpose is that if it is found to be relevant, it can be dismissed then and there, and the appeal can also be dismissed. Now, my lord, what is the scope, my lord? I'll just indicate. Today, I had filed an.
Whatever may be the scope.
My lord,
whether that
kindly,
is,
otherwise, my lord, dismiss.
then I'm extending. I will hear you. I'm extending the interim order. Ashul, the issue that arises for consideration.
I will either be able to satisfy or it will immediately be allowed. So if my lord kindly takes up any day after the
It was
vacation.
directed to appear under what heading? It is appearing in the list.
It is not appearing in the list. That because of the can it has come up, my lord.
List this matter under the heading contested application after yes.
Then extend my. Now an interim order has been twice extended. Now the suit has been filed in respect of a plot. If you lordship kindly come to the
Advocate Commissioner's appointment, मतलब short point, मतलब kindly.
Advocate Commissioner's appointment.
in
All short points, if it is taken,
in
no main
respect
matter
of
can be taken up.
the property, in respect of the property which thus belongs to him.
Yes,
Mr. Chatterjee, I'm extending the interim order. I'm keeping it
Yes.
just for publication. After hearing the learned advocates, interim order is still subsist. Only at the stage of interrogatories.
Well,
Long way to go.
Unfortunately, this is same matter, my lord.
What same matter?
Hello, 2013, my lord, is pending still partition suit, my lord. Kindly, unnecessary, my lord, adjournment, kindly. Only thing is the early disposal, my lord, let there be done.
What is the stage of the suit?
My lord, at the preliminary stage, my lord. On every occasion, my lord, they come with on some plea or other, my lord. And the difficulty is this, my lord. So many persons are there or the.
What happened to the application under section 10 of the Code of Civil Procedure?
My lord, that is pending on my lord on 26.
That is pending.
Yes, my lord, on 26. My lord, only thing there is nothing, only my lord to delay the proceedings. My lord,
This application under Article 227 of the Constitution of India.
My lord, 26 now.
Is that the instance of the plaintiff paying for
দুজনের নামটা দিয়ে দাও।
Yes.
Lordship, on behalf of the defendant, Lordship, may I just indicate this is from Baruipur and one Mr. Devashish Chakraborty.
Since I'm not inclined to take up this.
I am for the petitioner, my lord. The eviction suit, my lord, during the pandemic situation, COVID-19, my lord, the defendant could not file, my lord, the 717 application within time, my lord, and as such, my lord, section 5 application, the same was filed before the learned court, and the learned court was pleased to allow the said petition, my lord, on 3rd August 2021, my lord. Can you come to the order, my lord? Page 48, my lord. The petition was allowed since, my lord, there was an order from the Honorable Apex Court
Yes, then what happened?
Now, my lord, the present, my lord, civil tax junior division are, my lord, directed to, my lord, to hear out the entire section 5 application and along with my 7.2 and that order, my lord. Improved order, my lord, 1st March 2025, my lord. The application which has already been allowed, the same was, my lord, taken into consideration for further hearing, my lord. My lord, kindly come to, my lord, the improved order, my lord.
Order number
83, 1st March 2025, my lord. My lord, on perusal of record, but my lord, thereafter, my lord, on several occasions, order was passed for hearing of only 7.2 application by the learned court, and my lord, petitioner has been depositing.
What happened after that?
My lord, now, my lord, this is, my lord, they are trying to, my lord, hear out the entire, my lord, 7.1, 7.2 along with, my lord, section 5 application. This is for
No, by this order of 3rd of August, 7.2 application was fixed for hearing. That was not allowed. 7.2 was fixed for hearing.
My lord, the same was fixed for hearing. My respectful submission are only 7.2 application can be heard, my lord.
All right. So you point out to the what is the next date fixed?
Next date fixed, my lord. 20th September 2025, my lord.
Yes. When is the next date fixed?
My lord, that order is
30th of August it was the date fixed.
Then similar order was passed, my lord.
Next date.
Similar.
So I'm giving you liberty. You point out to the learned trial judge at the time of hearing that's only 7.2 can be heard, not 7.1. I'm giving you liberty to make that. This application under Article.
No further
Petitioner, my lord, expeditious disposal of the case, my lord.
Expeditious of what?
My lord, suit for declaration and permanent injunction, my lord.
Declaration of what?
Declaration of title, my lord.
Of title. What is the stage of the suit?
Stage, my lord, WS filed by the defendant and temporary injunction disposed of, my lord.
Temporary
Next date
injunction disposed of. Written
Yes,
statement accepted.
Yes, my lord. And next date, my lord,
Interrogatory is done.
Yes.
Order 11 complied with.
Yes, my lord. Order 11 complied, my lord. And next.
How can you say order 11 complied with? It's fixed for hearing on
No,
9th of December.
Complied, yes.
This application under Article 227.
Kindly comes the lordship impugned order dated lordship 23rd of
What is the
April.
nature of the impugned order?
Section 5 was allowed lordship 703 days delay in lordship order 41 rule 3 application without any rule 3 without any explanation. Kindly comes to the lordship application lordship. It should be considered lordship liberally. I understand lordship, but without any explanation, without treating the application as a miscase lordship.
What is the miscase for?
The lordship order 41 rule 3 application should be lordship first registered as a miscase. There are evidence should be taken lordship. Kindly consider the application for condoning the delay lordship. How they have lordship explained 703 days delay lordship. Only illness.
Section 5, Mr. Sannal.
Section 5 lordship court should lordship considered it liberally. I understand lordship, but lordship there some explanation should be there lordship.
I will recall the initial order which Mr. Parthopatim Roy and you appeared. Item number 1. I am recalling the order. 3 years delay. It's more than 703 days into 27.
Now, lordship, kindly consider.
2022 order, if I faintly recollect, March or May's order of 2022, you have filed in August, more than 3 years delay. So it's more than 703 days. ওটাকে recall করিয়ে দেবেন তো item number 1.
Now, lordship, kindly
choice
consider.
is yours now. Whether to press this or that will be recalled.
Now, lordship, kindly
ask your senior to come.
Court should at least explain lordship.
In this matter, your senior has not come.
No documents lordship has been lordship sought for from the lordship regarding.
I'm recalling that. I'm admitting this. I'm recalling that there are also no explanation. ... When they came to the learned advocate.
In this matter, lordship, Mr. Roy is not in this lordship. ...
When they approached the learned advocate at the time of drafting, not filled up. You are assisting him.
My lord, kindly comes to lordship their application.
I will recall that. I will recall that.
Kindly come to lordship the application made by the lordship appellant. It's a eviction suit lordship suit decree 2015. At the date of lordship passing of the judgment lordship, the defendant was there. Now lordship they have taken lordship the ground lordship all along lordship he could not lordship contact with the learned advocate. On this ground lordship the application has been allowed.
He was ill, Mr. Sannal.
I understand lordship. Section 5 lordship should be lordship treated as most.
No, you are not understanding. But cost was directed to be paid 1,000. You are not happy with the
legal
amount.
Service Authority lordship.
Oh, that is why. If it was paid to you, all right, you have accepted that.
Court should lordship at least some evidence how the lordship the delay has been explained in the section 5 application. Kindly once lordship comes to that.
All right, I will remember your submission.
I
Now, now everything, all submissions are recorded. I will remember.
Now this is lordship order 41 rule 3 application lordship in connection statutory appeal. They should lordship explain the delay.
I've also given a protection. Interim protection is also there, Mr.
Because lordship from 17 to 24 lordship they have taken time.
Mr. Sannal. Now I will recall that item number 1.
In this matter, my lord, I am appealing for the petitioner.
Yes.
Suit decreed.
Yes.
Can you turn to page 32?
Page 32. Yes. What is the impugned order?
Yes. Suit decreed against that appeal file. That is order 39, 1 and 2.
Appeal order 39, rule 1 and 2. Yes.
1 and 2.
Allowed.
Allowed. Well, can you consider how it was allowed?
Ex parte.
Ex parte allowed. May I read out, my lord, the order? This one number 2 to 5 late property appearance move petition for temporary injunction. This one now the petition temporary injunction is taken up for
party. No.
One learned advocate raised oral objection on behalf of the respondent number 1.
Is sir received as refused? Is sir received against 4 unserved? Who are you?
And the defendant number 1. Respondent number 1. I beg to get.
So you have refused, Mr. Rai. So service against you is complete.
After that, kindly. One learned advocate raised oral objection via the respondent number 1. As he has filed caveat.
Which portion? Which portion?
Last but middle. Now the petition for temporary injunction.
Yes.
Is taken off. Respondent number 1 in ex parte. One learned advocate raised oral objection on behalf of the respondent number 1.
You filed a caveat.
Yes. Caveat has no role to play as the notice was sent and accordingly refused by the respondent. even on Ogalatama steps filed or taken during hearing. My lord, once the caveat is lost, I don't know how the court came to the findings of the.
No, but Mr. Rai, are you taking steps to construct a boundary wall?
Yes.
That you cannot do now.
My lord, consider, if I could have understood it as disposed of.
That will be frustrating the decree. The appeal, not the decree, frustrating the appeal.
It is the finding. What is the finding? It is
Rai,
disposed of.
once an appeal has been filed, so the res sub judice, res judicata is destroyed when an appeal is filed.
He could have understood, my lord, if
the finality attached to those findings that goes.
What is, if you logically consider, when your lordship was pleased to ask me this question, yes, I said that I did make construction. The date on which the order was filed by disposing of the injunction application, what are the documents before the learned court below for passing of the order by disposing of the authority in 1 and 2 without giving opportunity of filing any objection to the same?
No, this could not have been disposed of, but in the meantime, you cannot make any construction.
That is, I can ask for stay also here.
Yes.
Injunction granted, I can ask for stay.
Yes.
So therefore, my lord, let the injunction be heard. So that is the only thing I can ask before your lordship.
By the লিস্টের দিকে দেখে বলুন।
মুড়ির টিন একটু ঠান্ডা
Yes.
Item number 39.
39, my lord, I beg to appear, my lord, for the plaintiff petitioner. Am I audible to your lordship, my lord?
Yes, Mr. Kormokar, you are appearing online in this matter and in other matter. Mr. Rai mentioned in the morning, you are not appearing in that matter. Mr. Devashish.
Before Mr. Kormokar starts, my lord, this is with respect to, I believe they want that 7.3 be implemented, and my application for 7.1, 7.2, that was rejected, and against that order, I filed two civil revision applications.
You have filed a civil revision, very
Lordship,
sad.
that was item number 2324. Lordship,
2324.
today, my lord,
What happened?
Just for adjournment, and Lordship is pleased to pass an order. Lordship, I'm praying, my lord, Lordship will, because it is Mr. Adil Rashid is appearing in that matter, my lord. But the difficulty is he has got to
with section 5. What is there, sir?
Lordship, I shall try to argue some new point, my lord.
Yes, try.
But Lordship will kindly here's 2324.
All right, 2324, make your submission first.
Lordship, I will.
No adjournment, sir. No adjournment.
Lordship, this is a case. Lordship, in October
2324 fight আছে. Give any one of your copy.
It is only the marking is there and the
marking will help me. Yes.
It may help me
also. Look, which is against you. Yes.
Lordship. So this is a case where the summons was served in October 2024 and the returnable day was in February 2025. In October 2024, my lord, the defendant's father, the defendant is a company though, the director's father, who was also a director at one point of time, Lordship, was admitted and was going through serious. Lordship, I have given all those documents, and he was going through serious.
No, when the summons was served, please give me
in
that
October 2024, the summons was served.
Well,
summons was
served on 25th of September 2024.
25th of September.
And through court, it was served on 4th October.
Lordship, my averment in the application was sometime in October, but I stand corrected. It was in September 2020.
When you entered appearance?
And Lordship, I entered appearance, my lord, on the returnable date, which was in February 2025.
That is not the law.
Lordship, Lordship, I understand, my lord. These people
That is
are
not
from
the law.
Lordship,
From service of summons.
30 days.
That can be from the date of appearance, provided summons was
not
served.
served.
It is a case of service summons served, so you have to file within 30 days, sir. So
Lordship, there are 3 points Lordship will consider. Lordship, this will anyway, Lordship, one of those cases which will go up. Lordship will consider 3 cases. First is, my lord, the summons were served, the returnable date of the summons was beyond 30 days. As on date, my lord, the judgments which are there, these are all on section 5, but none on the case of beyond 30 days.
I have dealt with the matter.
Lordship has dealt. Lordship, I
dealt with the matter.
Parvati Charan Rokhit. The judgment is there with my college friend, Milord.
This judgment also, which is in my favor, that it should have been.
Take into consideration.
I also suffered this, Milord, from Justice Sarkar's court.
Time, which was earlier in point of time. Don't invite the court to make some observation.
No, my lord. I'm not saying that. I'm not saying that, my lord.
So,
my lord, Lordship will appreciate.
Of 2 of my earlier decisions,
Lordship,
as well as the Supreme Court decisions, as well as the division bench decision.
My lord, division benches
Justice Shampar Sarkar's decision. I'm aware of that.
So
the number one, my lord,
settled, and it has been lastly settled. Some dispute cropped up. It has lastly been settled on 13th of August 2025 in the case of
Seventh-day Adventist.
Now
that judgment is also there.
Lordship, that is why, my lord, Lordship will, I will, Lordship, anyway, my lord, my instruction is, Lordship will kindly, Lordship, consider 3 points. Number 1, Lordship, it is there, Lordship, in Lordship's decision, but none of the Supreme Court says about, deals with those situations. If
in one of the decisions, Supreme Court was moved, SLP dismissed from my decision.
Okay. I did not know that.
Supreme Court, SLP dismissed.
So the 3 points. One is, in a case where the returnable date of the summons is not only beyond 30 days, it is after 5 months. It is, in fact, Lordship, Mr. Kormukar says, it is 6 months. After 6 months, the date of the second case is, Lordship, the defendants, my lord, although the suit property is within, but the defendants are not, my lord, within the jurisdiction, ordinary jurisdiction of this honorable court. So, my lord,
defendants are not within the jurisdiction.
They are from Bombay or Delhi, my lord.
Maybe the suit property.
The suit property is within.
Suit property is here.
Jurisdiction. I'm saying that, Lordship, in a case where, Lordship, these defendants, they were not supposed to know that after 30 days they have to.
Law.
That's the law, my lord. But lordship,
Ignorance of law.
lordship, that is ignorance of law. Lordship, I was seeking that adjournment for that day for that reason. Look, ignorance of law has that proposition.
Mr. Ali, will argue this, and Mr. Ali wants my lord to settle this proposition. Ignorance of law is an excuse.
The Supreme Court settled it. Mr. Kormukar is in his car, he doesn't know. The Supreme Court has said that ignorance of law is that is not a good law. That ignorance of law is non-excusate. Lordship, that is no more a good proposition.
What are you doing?
Lordship,
your client.
My client is Lordship running a business there of a tour and travels. That is my business there. Lordship,
what are you? Who is occupying here? This should
Lordship, I am occupying. To my Lordship agents,
your agents.
My officers, my lord, my employees are there. But there is no dispute with respect to that, my lord. I am occupying. I am running my business, Lordship, from this is my Kolkata office. So
you have a private limited company.
Lordship.
So you have your legal department. You have your legal department.
I'm not that
no, I'm asking,
big.
I'm asking you.
I'm not that
private
big, my lord.
limited company, you have a legal department.
No, my lord. I do not have a legal department. This is a family-run company.
What is the nature of this business?
The business is a
now
tour and travels business.
There are many statutory compliances which are required to be made. So,
not with respect to there is no statutory compliance that I have to have a legal department, my lord.
No. I'm not saying that. For that, you take the help of legal experts also on some issues for the purpose of carrying on the business.
Yes, my lord. I take legal help on some issues. Whether what happened within the period October to February, lordship, that my lord is. I have not stated that, but my lord, what I have stated is the director's father.
Filed an application under Section 5.
I have not filed, my lord.
So,
my case was that 7172, lordship. This is I have appeared on the.
You have two matters.
Two matters. 23, 24, and this is 39 and 40.
Yes. Yes. Where is your application under Section 7.2?
No, that is at page 49.
Yes.
And I have given all the details, lordship, how my father and I had to go to, lordship, I have to import machineries just to, lordship, keep him in an environment which is not threatening to him. He was diagnosed with a very rare disease of kidney failure, my lord.
Sir, these are issues cannot be done. You know, 1 day default, 1 month's default cannot be condoned. If there is no Section 5, if there is no provision for extension, Supreme Court says it has to go. In one matter, only 1 day's delay, defense has to be struck off. That's the law. I sympathize with your client. I'm not saying, but now in one of the matters which you are saying, which Mr. Kormukar has referred to, you know what happened there. There was no default. 7.2, even after that, there was no default, but there was only a short deposit, wrong calculation. I think 10 or 15 rupees less. But for entire month, entire period that was being deposited. And the defendant, immediately after coming to know of that, he on his own, the plaintiff did not apply for 7.3. He on his own, yes, deposited, then filed an application.
For regularizing the deposit.
Yes, that also not done. Affirmed up to the Supreme Court. That's the law.
This has become very draconian, my lord.
Yes, so now it's
become very draconian.
The law. That's the law. Now, there was only a ray of hope in Debashish's false judgment, paragraph 17, now taken away in the judgment of Seventh-day Adventist, judgment delivered on 13th of August. Gone. And your explanation, that is why I was looking at 7.2. Your explanation is you have not paid for Section 5, but in effect, that is for condonation, taking those grounds. Cannot be. Yes, yes,
Yes,
7 day
seventh-day
Adventist.
Adventist, yes.
For opposite party, he argued and case was given in this.
This is Swarnendu Ghosh.
Yes, so this is the
So, my Lord
one
will
point is that I will consider that with regard to the
beyond 30 days, there is a returnable date. The second is, my lord, the case of where the defendants, whether in a case, lordship, the defendants, they are not supposed, lordship, if the lawyers make mistake, there is an appeal. If the judges
Lawyers
make
make
mistake,
mistake?
there is an appeal. But if the client makes mistake, lordship, in this case, this cannot be pardoned.
No, I could not follow. Lawyers make mistake. There is an appeal meaning thereby.
Lordship, if I make a mistake
Yes.
in arguing a matter, and an order is passed against me, Lordship, the client has a remedy of appeal. If the honorable judge, Lordship, kindly do not take me amiss, there is a honorable judge makes a mistake, Lordship, there is an appeal. If the client makes a mistake,
hierarchy of appeals is being provided only for that.
but
Because there
that
might
is the
be
thing.
mistakes.
So
There might be mistakes.
the lawyer may not know the law, the judge may not correctly appreciate the law, but the client must know the law. That is Mr. Kormakar's submission. Must know the law, cannot be excused. He must know which is Tenancy Act.
Don't blame him because now he is on that side. When he will be in your side, he will be making a contrary argument then. So now he is placed in the armchair. He is placing himself in the armchair of a landlord, plaintiff. That is why he is taking that submission.
The armchair has a seat belt, I guess.
Yes, yes, he has armchair in the car also.
Yes.
Yes, anything more?
So, my lord, the second point was that I am not supposed to, lordship, the defendant is only supposed to take legal opinion after getting the summons. If I have given an explanation.
When you have taken legal opinion, show me from 7-2. When you approach the learned advocate for taking opinion, show me from 7-2.
From 7-2, lordship, I have what I've stated is that during the after receipt of summons, lordship, I was going through a very bad phase, after which, lordship, in fact, my father died. Lordship, paragraph 12, lordship, will see. At page 54.
Paragraph
12, my lord, at page 54.
Yes.
This is the ground, my lord, that I am not supposed to know, my lord, the legal consequences, and I have to approach the approach for legal opinion, and I have to take steps. In this case, I was going through a crisis situation, which I have shown the medical documents, my lord. It was extremely ill. I had to import machineries also from Singapore to support my father's health.
Two grounds cannot dwell together. Once you say that you are not aware of the technicalities, then the question of this medical these ailments.
No, I could not.
You have to take one.
Yes, I did not. I was not aware of the technicalities that I have 30 days. This is the time within which I must file an application. And I was, lordship, busy with my father's, tending to my father, who ultimately, lordship, he passed away, my lord.
Who is the tenant? Father or the son?
Lordship, the company is the tenant, but the father and son both were directors.
Anything more?
Lordship, and the third point is, lordship, that Justice Vishrup Chaudhury's judgment that there ought to be, lordship, section 40 of the Premises Tenancy Act, the Limitation
Has
Act.
not been considered.
Has been considered.
So, section 40, what does it say?
The 40 says that Limitation Act has
Because
to
I'm
be.
asking you, requesting you, then I have to make observations on that. Section 40 has been long considered. I have also considered. What is the effect of Section 40? Limitation Act applies. So Limitation Act, if the applies, if the separate period of limitation is there, what will happen? That will take.
That will take effect.
So,
Malad, the corresponding provision of Section 5.
No,
that
will not apply. Section 5 will not apply.
If no power of extension is given, that's like 34.
Because it has been said only once more than 2 months. It has been well explained prior to that decision.
I am aware of that, Malad.
If
these are the
you cite, then I have to consider, I have to make, please, I'm requesting you. If you cite, then I have to make observations on that decision.
This is my ground on my submissions with respect to my applications.
And you are relying on
for
the
7174.
single bench decision of this court. Supreme Court has held on Section 40. Justice Sanjay Kishan Kaul's judgment, Devashish Pal exhaustively decided on.
No,
Division bench has decided. I have in my decision, one of my matters, Mr. Chatterjee argued, where he has said all decisions are pari inquirium, starting from Vijay Kumar Singh. He said all decisions are pari inquirium. I've also considered that. Ashun, this application under Article.
So, and on this application, Lordship.
Let me first decide your application.
Very well.
Then others is the consequential. Second is consequential.
Consequential, Malad, I would say, and on their applications, the 7.3 filed. Their contention is that 7.3 ought to have not been. There shouldn't be any date fixed for 7.3. Automatic. Saying that since they have filed it,
consequences will follow. Let me first decide your application.
Only one thing, my lord, just to add one more cause of dismissal. If your lordship
One more cause of dismissal.
Yes, my lord, your lordship will kindly take the impugned order.
Yes.
The summons was served in September 2024. The application under 7.1 has been filed seeking leave to deposit the rent from January 2025. Whereas it ought to have been, my lord, from the next month. If your lordship will kindly take the impugned.
That is from appearance.
No.
Yes.
It has to be month to month, my lord. The moment he receives the summons, so every next month, my lord, I will place the section, my lord, because what?
No, that is there. No, he says he appeared when?
My lord,
in February. February 2025.
February 2025. And you filed that application? 7.1 and 7.2 filed on?
February 2025. On the first day. On the first day. Return of.
So,
17th of February 2025. 7.172 filed 17th of February.
17th of February. And
my lord.
Leave to deposit from January.
You are not a defaulter. You are regularly paying the rent.
Lordship, in rent control challans all are with me.
Rent control challans are
all with me. They have accepted till December 2023 or 2024.
Deposited before the rent controller till December 2024.
Till December 2024.
Yes. And from January,
Lordship, I have asked for 717.
From January. This application under Article आगे दुटो ना आगे दुटो order एक करें. Article 227 of the Constitution of India is at the instance of the defendant and is directed against the order dated 7th of August 2025 passed by the learned civil judge learned judge 11th bench Civil Court at Calcutta in ejectment suit number 10 of 2024. By the order impugned, the application under Section 7 within bracket 1 and Section 7 within bracket 2 of the West Bengal Premises Tenancy Act stood dismissed on the ground that the same were not filed within the prescribed period of limitation. First up, the learned advocate appearing for the petitioner submits that the summons of the suit was served on September 25, 2024, and the date of appearance of the defendants in the said suit as per the said summons was
17th February 2025.
17th of February 2025. First up, he further submits that on the returnable date, the petitioner entered appearance in the said suit and filed applications under Section 7 within bracket 1 and Section 7 within bracket 2 of the 1997 Act, praying for depositing the rent on and from the month of January 2025. First up, the learned advocate appearing for the petitioner submits that when a date has been fixed in the summons for appearance, when a date has been fixed in the summons for appearance and the applications under section 7 within bracket 1 and 7 within bracket 2 of the 1997 Act are filed on that date, the said applications could not have been dismissed on the ground of limitation. First up, in
Order 5, Rule 6, I'm relying on, where it says fixing date for appearance of defendant. The day under sub-rule 1 of Rule 1 shall be fixed with reference to current business of the court, the place of residence of the defendant, and the time necessary for the service of summons. And the day shall be so fixed as to allow the defendant sufficient time to enable him to appear and answer on such day. So, my lord,
there is no dispute with that. Time to file written statement.
5 months the court thought that will be required to enable me
to contest the suit. কি বললাম? The learned advocate appearing for the petitioner places reliance upon the provisions of section 7 within bracket 1 within bracket small b of the West Bengal Premises Tenancy Act in support of his contention that the petitioner in support of his contention that an application under section 7 within bracket 1 can be filed within 1 month from the date of appearance. First up, the learned advocate further submits that that one of the directors of the defendant company was seriously ill and the other director was busy in attending the said director, and for which the application under section 7 within bracket 1 and section 7 within bracket 2 of the 1997 Act could not be filed at an earlier point of time. First up, he further submits that since the registered office of the defendant company is at Mumbai.
It is.
No, you said in Mumbai, the registered office.
The registered office.
The registered office of the defendant company.
It is in Kolkata.
No,
it is not in.
Not the registered office.
3 directors are in Mumbai. 3 directors are in Kolkata.
Residence. Their residence is in Mumbai.
Not the registered office of the company. Registered office of the company is at Kolkata.
Yes. No, my lord. Registered office is in Mumbai.
The registered office of the defendant company is at Mumbai, and some of the directors are residing at Mumbai. The defendants were not aware of the provisions of the 1997 Act, for which the application could not be filed within the prescribed period of limitation. First up, paragraph. Yes, these are your submissions.
Order 5, Rule 6, Lordship. Order 5, Rule 6, Lordship.
Order 5, Rule 6 is Mr. Kormakal, learned advocate appearing for the opposite party, seriously disputes the submissions made by the learned advocate for the petitioner. First up, he submits that as per the provisions of section 7 of the West Bengal Premises Tenancy Act 1997, the applications under section 7 within bracket 1 and section 7 within bracket 2 ought to have been filed within 1 month from the date of service of summons. First up, he submits that since the summons was served on 25th of September 2024 and the application and the said applications were filed only on 17th of February 2025, the learned trial judge was right in rejecting the applications, rejecting the said applications. First up, heard the learned advocates for the respective parties and perused the materials placed. First up, section 7 within bracket 1 within bracket A of the West Bengal Premises Tenancy Act states that on a suit being instituted by the landlord for eviction on any of the grounds referred to in section 6, the tenant shall, subject to the provisions of subsection 2 of this section, pay to the landlord or deposit with the civil judge, all arrears of rent, calculated at the rate at which it was last paid and up to the end of the month previous to that in which the payment is made, together with interest at the rate of 10% per annum. First up, subsection B of clause B of subsection 1 of section 7 states that such payment of deposit shall be made within 1 month of the service of summons on the tenant or, where he appears in the suit without the summons being served upon him, within 1 month of his appearance. First up, clause C of subsection 1 of section 7 states that the tenant shall thereafter continue to pay to the landlord or deposit with the civil judge month by month by the 15th of each succeeding month a sum equivalent to the rent at that rate. First up, subsection 2 of section 7 comes into operation if a dispute as to the amount of rent payable by the tenant has been raised by the tenant. First up, in the case on hand, the tenant has not disputed either the rate of rent or the period of has not disputed the rate of rent. First up, the suit is on the ground of default.
It is on the ground of default. They have disputed the rate of rent, my lord.
They have disputed.
They have
All right. In the case on hand, oita kete din. First up, paragraph. Section 7 within bracket 1 of the 1997 Act does not contemplate filing of any application, and the tenant is upon a suit being instituted by the landlord on any of the grounds enumerated under section 6 of the 1997 Act, is obliged to pay or deposit the entire arrears of rent within 1 month of the service of summons on the tenant, or where he appears in the suit without the summons being served on him, within 1 month of his appearance. This full stop. The time limit of 1 month from the date of appearance operates in a case where the defendant appears without the summons being served upon him. Full stop. It has been admitted by the defendant petitioner herein that the petitioner entered appearance in the suit after the summons was served upon him. Therefore, the second limb of clause B of subsection 1 of section 7 shall not come to the aid of the petitioner in the case on hand. First up, thus immediately upon service of summons upon the tenant, the tenant was under a statutory obligation to deposit the arrears of rent within 1 month from the date of service of such summons, and thereafter continue to pay to the landlord or deposit with the civil judge month by month by the 15th of each succeeding month, a sum equivalent to the rent at that rate, full stop. Paragraph, in the case on hand, the defendant appeared on the returnable date and chose to file an application under section 7 within bracket 1, and instead of depositing the rent for instead of depositing the rent even on that date. Full stop. Paragraph, the some of the directors may be residing outside the state, but the tenant defendant, being a private limited company, cannot take the defense that they were not aware of the proceedings, and they were not aware of the provisions of law operating in the state where the suit property is situated, and and they are a tenant therein. Full stop. Paragraph. The learned trial judge it is now well settled that the delay in filing the application under section 7 within bracket 1 or 7 within bracket 2 cannot be condoned under section 5 of the Limitation Act. Full stop. The time to file the said applications also cannot be extended in exercise of powers under section 151 of the Code of Civil Procedure. Full stop. The learned trial judge took note of the decision of the Honorable Supreme Court in the case of Vijay Kumar Singh versus Amit Kumar Chamaria and another, reported at 2019 10 SCC 660, and correctly applied the provisions of law laid down therein to the facts of the case on hand. Full stop. This court, therefore, in view of the aforesaid discussion, this court is of the considered view that the learned trial judge was right in dismissing the applications under section 7 within bracket 1 and section 7 within bracket 2 of the 1997 Act. Full stop. CO number such and such accordingly stands dismissed. There shall be, however, no order as to costs. Other matter is also the same.
23, 24. 39 and 40.
28 and
39 and 40 arises out of my.
If you said 28 and 29 same. Acha,
No, 23 and 24.
23 and
23 and 24 same. And now the other is the
39 and 40.
What has been done here?
Lord, 7.3 has been kept pending to be heard on a next date. Lord, my contention before your lordship today is, Lord, as a consequence of dismissal of 7172, Lord, 7.3 follows. No further hearing is required. It is consequential, my lord, it has to follow.
Filed by them. Lordship, Lordship will keep.
Lord, that also I filed 7.3, Lord, before their filing of 7172.
I'm recording in view of this, that order. Ashun, this application.
It on that day so that the same submissions they can make on that day.
What submissions? Nothing. Now you have challenged, so that could be a good ground if you succeeded 7.3 sometime. Now in view of this 7.3, this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 10 dated 7th of August 2025 passed by the learned Judge 11th Bench Civil Court at Calcutta in ejectment suit number 9 of 2024. So by the order impugned, the learned trial judge
Not my 7.3 was filed prior to their 7.1 and 7.2. I filed 7.3 on 14th of January. They filed 7.1, 7.2 on 17th of February.
Oh, this is by the same order.
Same order.
Oh.
Same order.
So both of you have challenged two portions.
Yes, my lord, I'm grateful.
You should admit both, and it should be kept in December. You both have come up.
You know? by the order impugned, the by the order impugned, the application under section 7 within bracket 1 and section 7 within bracket 2 of the West Bengal Premises Tenancy Act stood dismissed, and a date was fixed for hearing of the application under section 7 within bracket 3 of the West Bengal Premises Tenancy Act. First up, the opposite party herein, party or parties, opposite party herein challenged the portion of the order dated 7th of August 2025, whereby the applications under section 7 within bracket 1 and section 7 within bracket 2 of the 1997 Act stood dismissed by filing a civil revision application being CO number. What is the CO number such and such? And this court by an order dated বলে আজকের দিনের অর্ডারটা করে দেবেন, dismiss the said civil revision application. Full stop. Section 7 within bracket 3 of the heard the learned advocates for the respective parties and peruse the materials placed, comma, section, full stop. Section 7 within bracket 3 of the 1997 Act states that if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein or within such extended time as may be granted, comma, the civil judge Mr. Kormokar, it's better that 7-3 is to be hard. Let it be hard.
Nothing remains to be hard. Lord, your lordship has decided. Lord, your lordship has decided. Lord, the Seventh-day Adventist has Lord clearly decided. Lord, nothing remains to be decided in 7-3. Even no application is required. Your lordship knows much better than me, Lord. I need not even file an application under 7-3. It is automatic.
But hearing or within such extended time as may be granted.
Comma, the civil judge shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. Full stop. In the case on hand, the prayer of the opposite party to deposit the rent for the from the month of January 2025. Thereafter, you have also not deposited.
7-1 was rejected.
On and from the month of January 2025 stood rejected. Full stop. It is also not in dispute that the rent from the month of January 2025 has not been deposited with the learned trial judge or paid to the landlord. Full stop. It is well settled that in the event the tenant fails to comply with the provisions of section 7 within bracket 1 and section 7 within bracket 2 of the 1997 Act, the provisions of section 7 within bracket 3 of the 1997 Act stands automatically attracted. Full stop. In the case on hand, the in the case on as observed herein before that there is non-compliance of the provisions of section 7 within bracket 1 of the 1997 Act by the opposite party herein. Full stop. Though it is true that the petitioner has filed an application under section 7 within bracket 3 of the 1997 Act, but in view of dismissal of CO number, CO number such and such, nothing remains to be decided in the application under section 7 within bracket 3 of the 1997 Act, and the same stands allowed, thereby striking out the defense of the petitioner against delivery of possession. CO number such and such stands allowed. There shall be, however, no order as to cost. The other CO number. For it, you have filed the others. The next CO.
Yes,
is the other. So which one is can be? Because there are two suits.
Yes.
Please give the CO numbers relevant to each other.
Obliged, not deeply obliged.
Grateful. Yes.
347 is with respect to ejectment.
Please give corresponding CO numbers. সেইটার সঙ্গে সেইটা tag করে দাও।
Obliged.
39 and 40 একই, ওই 23 সঙ্গে কোনটা?
Before rising, before rising, matter, when 3 PM matter.
3 PM, nights 4. I cannot say it loudly. What is the exact time now?
Already has been fixed, my lord. Mark has 3 PM.
Sarkar, Maji, the difficulties for yesterday. These are the motions which are yesterday's motions. And you have taken a resolution that yesterday's matters should be taken up. So today's matters I have completed. Yesterday's matter I have also proceeded to this extent.
Tomorrow, your lordship, but tomorrow.
Will remain in the list, please.
Outstate, at least, my lord, I need to get back.
I follow, but what can be done? You have taken a resolution. If these are not taken up, you will come and say, yes, these matters are not being taken up.
Lordship has got a good case, I can all say that. Lordship has got a good case towards us, I can say this much.
But
my lord, the only thing is that kindly considers this also.
What is your item number?
428. Lordship was hearing that matter, Lordship remember.
That bank.
Outside of the house.
Where is the bank? Yes, madam, can you stay your hands for a limited period? Because this matter.
Anyways, 10 minutes, madam, because the revision itself.
Madam, no, I do not have any difficulty in taking up. The fact remains, I do not know how many working days will be available now. That is the difficulty. Motions are there. I do not have any difficulty. That is why I am asking today. I am keeping it. Please consider whether you can stay your hands for a limited period. I will consider. It will remain in the list. If I get time, I will take it up. Because motions, at least yesterday's matter, I have to reach.
Tomorrow, my lord, I am outside, it will be sold.
What is the date of auction?
The date of auction was, my lord, on 1st August. Only that they did not get a buyer. If they get a buyer, they'll give it to him.
Oh, so now it has been postponed.
Not postponed, my lord, it's rolling. If he gets a buyer, he'll sell it immediately. And
No,
then
no, what was the date of auction? That has gone. They have not got a buyer.
They'll get a buyer, they'll sell it. They, my lord, now they are not under any, my lord, difficulty. Because there is no stay. Lordship said, Lordship will hear it out, they'll say there is no stay. And if a third party right is created, I will have no case.
Cross the hurdle of materiality, my lord.
I am one of the merits, my lord.
All right, let it remain. I will.
Consider, my lord, tomorrow, your lordship, kindly.
Tomorrow.
391, my lord, your lordship, kindly consider.
All right, come tomorrow.
May I try to?
It will remain in the list.
I shall try tomorrow, my lord.
All right.